Hey guys, I know this is starting a little early, but I wanted to get some stuff on the record before the court starts, which I think we have about 10 minutes, and that ought to do it. And I'm watching it on another screen here. And that's because I made the mistake of looking at comments on Law and Crime and Twitter about what's going on with the case. And that's always horrifying. Switch over to here. So what happens if she's not found insane? Of course, she just goes to prison, right? What if she is found insane? Then what happens? All right, let's take a look at this document. The person gets committed, and under the law, they can be committed or should be committed to the maximum length of the sentence they would have. Okay, right. You're not getting off at all, right? You're going into this mental institution forever. That's a big maybe, and I'm not saying it's nothing, because it isn't. It's significant, but that's not how it works. So look what it says here. Commitment to an institution or release on conditions. So when I think commitment, and maybe when you do, you would think, well, you get committed, you go off to the nut farm, and that's where you are, right? But look what it says, institution or release on conditions. So you can be committed to the department of whatever, we'll look at that in a second, either in an institution or released on conditions. So here it says the court must determine whether there will be institutional care or conditional release. Now, I grant you in this case with Schabusiness, if she's found insane, it's going to be institutional care because of how dangerous she is and all that. The point is the court has to make that decision first, and it tells the factors here, nature and circumstance of the crime, mental history, and all of that stuff. So there you go. You could be committed and released on conditions, or you can be put in an institution, and she will be put in an institution. I doubt that, but will she just stay there? And the answer is that it all depends. And here it talks about how long the commitment can be made for, but I want to get down to here. It is interesting how you can refuse medication unless there's a court order. Here's the thing, petition for conditional release. This is what I'm talking about. So Schabusiness gets committed, and here we go. She gets committed and she's put in an institution, and she thinks she's getting better. Maybe the people there think she's getting better. She can file a petition for conditional release. So she can say later on, circumstances have changed. I can slide out into the community under certain conditions. And that happens in this state too. And the criteria really is whether you're still dangerous to yourself or others. And I think that's the criteria there, like it is here. So one of the hopes, if you're the defendant and being found insane, is that at some point, let's say you actually are insane, at some point you get your wits back about you, they get you the treatment you need, you're no longer dangerous or anymore. You might be released either by conditions or potentially have your commitment terminated, but at least released with conditions. Whereas in prison, you're going to be serving prison time. So that's the potential upside for being found insane. And it still exists here. And some people have misinterpreted the commitment to maximum sentence to mean that she's automatically going to be in an institution for the same length of time she would be in prison. And that's not what the law is. And let me show you. And I'm showing it here on the screen, so it can't be. Let me slide down through it for anyone who wants to scroll through it and read this examples here. Then I'm going to switch the screen because we still got a few minutes left. And I wanted to do that. Now, again, I'm not saying she's going to be let out or whatever. I'm saying what the law is. And let me hit this here because this is interesting. Am I making this up? I am not making it up. I show you the document so you can see what I'm also looking at. Here's the Wisconsin Department of Health Services Conditional Release Program. Supervising clients. These are considered clients once you're found insane. Less than 1% of all criminal pleas result in a not guilty by reason of mental disease or defect. Commitment under Wisconsin statutes. And remember, commitment can be on conditional release. And this manual is for the agents who do that. And it tells the criteria. We've been over that every day I've streamed. I'm not going to repeat it because I know the people in this chat know what it is, even if people on Twitter and Law and Crime do not not slashing law and crime, just the people who comment on it, who act like they know and they don't know and don't bother to find out. All right. People committed under this legal status are known as clients, not offenders. They're not considered to be convicted of the crimes in which they were charged. As such, they may vote during their commitment. And I get that. I think even insane people voting, I don't know how you can tell the difference in the results we get in an election. So I'm all for insane people voting. Have no problem with that. The government is insane all the time. Commitment to the Department of Health Services. People found not guilty by reason of mental disease or defect are committed to the Department of Health Services. The committing court determines the placement, and that can be the Mendota or the Winnebago Health Institutes or the community, right? And we just went over that. It's not out of my imagination. It tells how the court decides whether you're going to be in an institution or not. The commitment period can be quite lengthy, you know, the maximum sentence that you would get for the crime. But how you're going to serve that, the court can say, well, I'm going to let you out on conditional release, or I'm going to commit you to an institution. Now, again, if she's found insane here, I have no doubt that the court is going to institutionalize her. I mean, of course, I doubt even her attorney would object to that. I've seen, and the face eater, I think he volunteered to do that as part of his plea bargain, as an example. But the glory of this is that every once in a while, the person gets to petition for conditional release, even if you are in an institution. So if the treatment works and they're able to help you stop being insane and then stop being a danger to yourself or others, you might be able to be let out, maybe during the day, maybe under certain conditions and things like that. There'd be greater flexibility than in prison. Because this idea that, oh my God, you got to stay in an institution as long as a jail sentence is not how Wisconsin does it, because they use the traditional approach that if you were insane at the time of the crime, you're not guilty of it or you're not responsible for it. So we're not trying to punish you. We're trying to help you. That's why you're a client and you can vote. Let's see if there's anything here that we can look through. There are some interesting comments. Again, this manual is for the agents who handle this, not imaginary things on Twitter. The committing court sets the commitment period. The termination date of the commitment cannot be extended or shortened by the agent. Time period cannot be stopped or told. There are no administrative early discharges for not guilty by reason of mental disease or defect commitments. The committing court may only terminate a commitment, not shorten it, but they can change the conditions of it. They can let you out of the institution and into release. So, well, I just read exactly where they send these people, and that is options include the Mendota Mental Health Institute or the Winnebago Mental Health Institute. It says the committing court determines placement options include an institution, and typically those two is where they say, or the community through the conditional release program. So that's the criteria here for getting conditional release. The standard for receiving conditional release is dangerousness. The court will deny a petition for conditional release if it finds clear and convincing evidence that the person would pose a significant risk of bodily harm to themselves or others. That's pretty much the standard here. I think it's a standard in a lot of places. They also put serious property damage in there, which is kind of cool. People found not guilty by reason of mental disease or defect may petition the committing court for conditional release every 6 months. So if she is put in an institution, she will have the ability to go back to court and say, I'm better now. I'm not dangerous to myself or others. Let me out. And the burden really is on the state to say, no, it's still not true yet. Again, I'm not saying it's easy to get out. I'm not saying she wouldn't serve significant institutional time, potentially up to the maximum of her sentence. She apparently behaves quite badly while she's in these facilities. So I don't know. The point is to straighten out what the actual law is, which is the court will decide whether the commitment period and then whether that commitment is institutional or conditional release. And if it's institutional, over time, she can petition to be let out. The success of that just depends on things later. Sometimes when these guys get out of the news and years go by, they are let out on conditional release very quietly. So that can happen, and that's better than spending the rest of your life in prison. So that's the potential upside to the insanity part. Well, no, this says the lunch break has still got 18 minutes. I was racing along thinking that they would be back at 2:15. So if they do start, I'm going to switch back over to that. So let's see. I don't know off the top of my head the jury instructions. I think I read those the other day. The jury was told at the beginning of the trial that it would be multi-phase, that there would be a guilt phase, and then there would be a phase for responsibility. I think they're also told that the judge will commit this person if they're found insane. I don't know if it's explained to them that commitment can be institutional or release on conditions. Again, if she's found insane here, this judge is not going to give her release on conditions. She will be an institution, so I don't think it makes a difference whether the jury knows that or not. The jury would know that she'd be committed, and most people, when they hear commitment, think it would be inside. That a commitment's inside. You hear involuntary. You got involuntarily committed. That's inside an institution, right? So that's how I would have taken it. But that's why I just love going and looking at what the actual law says, because I read the statutes this morning when I saw some things that tweaked my radar, and then I read the summary that they use for judges to handle cases. We have a similar document like that in North Carolina. It's a great backdoor document, like a judge's handbook sort of thing, to kind of gives you shorthand of what the law is. And then here we're looking actually at, let me flip back over here to the handbook from the Wisconsin Department of Health Services on conditional release and how that occurs and what the standard is and how you can get it and who does it, which is the court and all that. So there we go. Now, let's get into some of this chat. So I see a comment here. She gave an opinion on the other experts' report. Yeah, but I think when the other experts testify, then they're going to give an opinion on her report and say, well, I think this person was wrong here, or that sort of thing. What's interesting is when we see this, is that the other experts were, I believe, appointed by the court, not by the DA's office, because the court has the ability to appoint experts in the matter when it's insanity in Wisconsin. Every state's procedure's different. So that's one of the things you have to do, is remember that every state can handle all of this stuff differently. And insanity is a very state-specific topic when it comes to how to handle it under the law. Some of the concepts are general, like, getting out if you're no longer dangerous to yourself or others, and being found insane not being the street definition of insane, because what she did is absolutely insane, but it has to do with whether this mental defect prevented you from knowing right or wrong or created compulsion that you couldn't withstand. Because can you really think that Taylor Schabusiness doesn't have something wrong in her head? And then on top of that, the drug use spiking that up even more. So let's see. Is there a point where the institution could declare she's incurable? So she's got a right to petition. That doesn't mean that they have a right, of course, to support her in any way. So I don't know that it'd be fair to say you'll never be cured. But that can be effectively how it is. I mean, sometimes these people never come out. We'll see. I mean, it may be that she gets the right combination of things. Sometimes they sit in there forever, but sometimes they are able to be released on conditions and things like that, which they might not have access to if they were in prison on a different type of sentence. That's not easy. It's not fun being one of these institutions. And I've been in it with somebody who was not guilty by reason of insanity. I've been in a secure mental facility and talked to a person who was on medication to reduce the effects of the insanity, which they certainly did suffer from. So I have some personal experience in it. Although I'm crazy myself, I don't meet the legal definition of that. So let's see what else we got here. But that didn't take as long as I thought it would. And plus, I thought they were going to start at 1:15 their time. But I guess that's moved out a little bit. So I wanted to hurry and get on the record these documents about commitment. I'm going to take them at their words. They got another 15 minutes here. And I'm going to switch back to this other document that I was showing a minute ago for people who are coming in. Let's see. I'm not the fastest at this. 0600. This is all about how to handle commitments and things. It's quite long, but let's take it back up to the beginning again. So again, if you were convicted of a crime after this period, there's newer statutes that talk about how long the commitment period can be, okay? And that can be up to the full term of what a criminal sentence can be. But commitment can be institution or conditional release. And if it's institutional, then you are also allowed to petition for conditional release later. It's just what the law is. These people are clients, not criminals, once they enter this situation. Persons found not guilty by reason of mental disease or defect for offenses committed after January 1st, 1991. The right to reexamination is replaced by the right to petition for conditional release. And I read a little bit of that this morning. I read some of the statute, and then I read this, and then I read the stuff from the Department of Health Services instead of using my imagination. A petition for conditional release may be filed if at least 6 months have elapsed since the initial commitment order, or the denial of the previous conditional release petition, or the revocation of conditional release. I think here it's like a year, maybe. I don't really remember. But again, that depends on the state. There's not one law that governs the United States of America. We have federal law for what it covers, and then every state has its own laws. They have to comport with the federal Constitution, but outside of that, there is a lot of variety. Let's see here. Okay, I'm looking at the law and crime. It's just showing that janky state seal they have there. I guess that's the state. You're not even embarrassed by that. Let's take it back up here. Let's find some of those jury instructions that we want to see, since we got a few minutes here. I did see this too, the right of a person to refuse medication. They can refuse it unless the court orders them to do it. Duration of the commitment, we talked about what that can be. Trying to flip it back up here to the second phase of the trial and jury instructions for that. So here's some instructions. We'll go back up further if we need to. The burden of proof is established by the statute. The defendant, and of course her attorney said this in his opening. I was listening to it. I wasn't able to watch it. I was doing some other stuff. The defendant must establish the presence of the mental disease or defect defense to a reasonable certainty by the greater weight of the credible evidence. That's the defendant's burden, not the state's burden now that they're in phase 2. Jury instruction 603 is the preliminary instruction to be read to the jury before the second phase of the trial. And it explains that the second phase will be concerned with whether the defendant is responsible or not responsible for her criminal conduct. It emphasizes the second phase is concerned with the defendant's mental condition at the time of the offense, and informs the jury that if the defendant is found to be not responsible, she will be committed to the custody of the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to himself or others if released under conditions ordered by the court. So I think that answers the question that came up there for me and you. Thanks for the question about what they're told. 605 looks like we're based on a plea of the presence, and that didn't occur here because remember, she pleaded not guilty, and then she pleaded not guilty by reason of insanity. That's why she got this bifurcated trial. It is possible in Wisconsin to plead guilty to having committed the crime, but not guilty by reason of insanity to try and be not responsible for the crime. And of course, her attorney inherited this after she hit the other attorney in open court, and he withdrew, which was reasonable. Let's see if there's anything here worth looking at. But really, you're talking about, does the person have a mental disease or defect, and whether that has the required effect on the defendant. Did the defendant lack substantial capacity either to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law? And you cannot answer either one of those questions yes if in doing it you think that occurred because of the voluntary use of drugs. So you do see a lot of testimony about that in this morning, with the state saying, well, she was on meth, smoking meth, right? And smoking weed and stuff, right? Because if she's just kind of lurking crazy out there, I mean, how many crazy people are out there all the time now, just talking to themselves and wandering on the streets? There's mentally ill people everywhere. But being mentally ill is not the same as being violent. And the question here is, if she became violent and had, this compulsion or whatever, or feeling of I can kill this guy if I want to and do these things to him, if that arose because her ordinary state of mental illness is like here, but then when she gets on meth and marijuana and something, then she starts thinking, why don't I choke somebody and tear them apart? That is not insanity under the law. The voluntary intoxication is not a basis for insanity under Wisconsin law. So that's one reason why you hear the state making a big deal out of this, because they'll say she did know, the state's going to say she did know that what she was doing was wrong. She just chose to do it. It's just how she is, but she knew it. Now, she may be bonkers. She may be crazy. She may have personality disorder. She may have a lot of things wrong with her. She drew the short stick mentally and had terrible things happen to her when she was growing up or whatever. But she knew what she was doing was wrong, and she made choices to continue to do it. So she's not insane under the definition of the law. But even if you disagree here, you have to see that her normal level of bizarreness in her personality, she's not normally going around cutting people's heads off and stuff. She did this when she was high on meth, and that was her choice to do. When she's not high on meth, she's not cutting people's heads off. And under the law, if your violent act occurred because you went crazy because of this combination of drugs you were on that enhanced your normal level of craziness, that is not a defense. So that is, that's my summation of what we got. So I see a comment here. The defense psychologist was awful. Yeah, I listened to it, and I'm gonna give her some credit for this. She didn't try and weasel out of the fact that Schabusiness was on drugs, and that drugs can cause the type of drug she was on can cause her to hallucinate and think different things and stuff like that. She also didn't try and slip away from the fact that other experts had different opinions than she did. So I appreciate that she said that. You know, whether you concur with her opinion that at the time of the crime, Schabusiness was insane as the law defines. Notice that she wasn't saying insane, but she was talking about the mental disease or defect and whether it impacted Schabusiness so that she didn't know the difference between right and wrong and also couldn't control herself. So that was her opinion. But if that was because of drugs, then it's a no-go. And she did admit that she was smoking meth and whatever, weed and whatever else she probably get her hands on. Now, I did notice that the father, you know, he testified too, and he seemed to think that the drugs is what led to this. And, you know, he had some choice words to say for Schabusiness's husband, probably accurate about the destructive nature of that relationship. But ironically, his testimony that, you know, he took her down the wrong path and got her on all these drugs is really helpful to the state, because if you agree that she was crazy at the time, but you think the drugs were the launching pad for that, then her defense should fail. So let's see. Will the jurors know that she can be released if she's committed versus prison? It seems important for them to know. Well, I don't have the whole jury instruction here, but I did read what I do have off the top of my head, because I haven't looked up the whole thing. But it says it says the jurors will be instructed under juror instruction 603, and I think they started to have a jury instruction conference, but I haven't heard all the ones they're going to do. That this second phase is concerned with the defendant's mental condition at the time of the offense and informs the jury that if the defendant is found to be not responsible, she will be committed to the custody of the Department of Health Services and be placed in an appropriate institution unless the court determines that she would not pose a danger to herself or others if released under conditions. So if that's what the jury instruction says, and you don't get from that an understanding that she could be out on the street even under conditions at some point, then that should, you know, the jury should understand that. And the institutionalization is obviously an issue with dangerousness, and that's what the jury instruction also contends with, but it's not punishment. So in theory, you know, they could create a drug next week, a new drug, because we're all trust drugs now. So if they come up with a new drug that just cures her insanity, and all she wants to do is garden and plant flowers and things and paint houses and stuff. She's a model citizen. If she convinces the right people of that to support her, goes to court for a conditional release, then she should get it. If she's not a danger to herself or others, that's the standard. And if you're bleeding over into, well, that's not fair or whatever, I hear you, but you know, there's a fork in the road here. And if she's criminally responsible, then she gets this criminal sentence. But if she's not responsible, then she's a client. I showed that a minute ago, and let's bring that back up here. She's a client at that point. And as a client, if she's cured, she should get out. That's the whole point of this. I'm not aware that this is civil at this point. She's having an affirmative defense to the criminal conviction she's got as part of her trial. She's in the second phase of a criminal trial, as I see it. All right, here's the Department of. Let me check here and make sure I'm not. Yeah. Well, now they moved it back to 15 more minutes on. Oh, wait, am I behind? Oh, gosh, guys, I'm sorry. They're actually doing a trial, and I'm going to switch over to it right now, and I apologize for my lameness. But we did have a good discussion, I think. Share screen. Sorry.
And you indicated that you must have that doctoral degree. Where did you obtain that degree? I was from Iowa State University.
And do you have, can you just go through briefly your education prior to that degree?
I completed a bachelor's degree in psychology from Cardinal Stritch University, as well as a Master of Science in Clinical Mental Health Counseling from Marquette University before completing my doctorate at Iowa State.
And Doctor, through your professional work at the Wisconsin Forensic Unit, did you have an opportunity to work on the present case, State of Wisconsin versus Taylor Schabusiness?
Yes, I did.
How did you become involved in that case?
And so I was requested to complete 2 court-ordered competency evaluations in this matter.
When you say court-ordered, does that mean that the court is the party that retained you rather than either the state or the defense?
Correct.
Yeah, and when was that first evaluation? When was the first report filed?
That was in November of 2022.
And when was the second report filed?
That was earlier this month in July of 2023.
Can you, you mentioned that you were retained by the court to do a competency evaluation, and earlier you also mentioned that you do NGI evaluations. Can you explain for the jury the difference between those 2 types of evaluations?
Yeah, so those are 2 entirely different types of evaluations that are guided by 2 different state statutes. And so competency pertains to a defendant's current mental status. It is independent of the mental state at the time of the alleged offenses, and it pertains to whether or not the defendant presently has substantial mental capacity to understand the pending proceedings or to meaningfully assist in their defense. Whereas the state statute for NGI dictates it is about the defendant's mental state at the time of the alleged offenses, and specifically, was there a qualifying mental disease or defect that contributed to a substantial lack of capacity to appreciate wrongfulness of conduct or to conform conduct to the standards of the law.
Excellent. So he detailed the difference between
And you indicate that
competency
you
to stand
have
trial
substantial
and sanity
present
at time of
experience
crime.
in both of those types of evaluations. Is that correct?
Yes.
Now, they are different evaluations with different standards. However, are the materials used to evaluate those often similar?
I would say that collateral records are critical in both evaluations, although in competency, those records would focus most heavily on the present time and present functioning, whereas for NGI, it would be focused upon functioning at the time of the alleged offenses.
And can you talk about the records that you reviewed regarding Ms. Schabusiness for each of the 2 competency evaluations that you performed?
Yes, and so I reviewed the criminal complaint for the underlying matter. I reviewed all previous psychological evaluations that were completed in reference to this case, including competency and NGI reports from multiple examiners. At both times, I reviewed her contemporary treatment records from the Brown County Jail. And during the most recent evaluation, I also had the opportunity to review a discharge summary from a treatment episode at the Nicolay Psychiatric Center in 2021.
Did you, subsequent to the evaluation, were you also provided with copies of materials from an inpatient stay at Bellin Psychiatric or 2 different inpatient stays at Bellin Psychiatric?
Yes, after submitting my most recent report, defense counsel provided me discharge summaries pertaining to those 2 episodes of inpatient care.
And were all of those records taken into consideration when you either rendered your opinion or provided testimony at competency hearings in this case?
I would say that all of the sources that I mentioned initially were considered in reaching my opinion in my report. And then those Bellin records I did consider in preparing for testimony, but they did not alter any of the opinions offered in my report.
And in addition to reviewing collateral records, did you conduct personal interviews with Ms. Schabusiness?
Yes, I did.
And what were the dates of those interviews?
And so the most recent interview, I'm just referencing my report here, was on July 12th of 2023. And for the initial interview, I would reference to refresh my memory, that report from November of 2022, the date of the interview was November 17th, 2022.
And were both of those in-person interviews?
Yes.
And can you estimate approximately how long you met with Ms. Schabusiness in those interviews?
On both occasions, it was roughly 90 minutes, perhaps give or take a few minutes.
Doctor, when you were reviewing the records and ultimately when you had to come to an opinion in this case, had you encountered prior diagnoses that had been assigned to Ms. Schabusiness at various points in time?
Yes.
Were you aware that at some point in time she had received a bipolar diagnosis?
Yes.
And do you recall where that came from?
That was during her inpatient treatment at the Nicolay Psychiatric Center in 2021.
And Doctor, what did you note with respect to that particular diagnosis? Were there any concerns when you saw that?
Yes, a concern I had with that diagnosis is that for one to be diagnosed with bipolar disorder, it's specifically within the diagnostic criteria for that condition that the symptoms cannot occur exclusively in the course of substance intoxication. And I noted that there's multiple collateral sources suggesting that she was abusing methamphetamine very extensively leading up to that treatment episode. So I was unable to really see how the treatment providers could have parsed out to what extent any psychiatric instability derived from the methamphetamine use versus an actual underlying mental illness.
And did you have an opportunity to review the discharge summary from Nicolay Psychiatric?
Yes.
And in that discharge summary, is there a discussion of how she presented upon arrival compared to how she presented upon her release 21 days later?
Yes, it was noted that there was a remarkable difference and that psychotic symptoms were evident upon admission, including hallucinations and very disorganized behavior, although those symptoms were determined to be largely resolved by the end of that treatment episode.
Does that suggest anything to you with respect to the substance abuse that was indicated at the outset?
And so it's, again, difficult to disentangle to what extent that improved mental status resulted from any medication she received in the facility versus her mere forced abstinence from intoxicants.
Based on your professional education and experience of the types of symptoms that were noted upon arrival at Nicolay Psychiatric, can those symptoms also be associated with the methamphetamine use solely?
Yes.
So it's possible for someone to manifest those symptoms solely based on meth use without having any underlying mental health illness?
Objection
Yes.
calls for speculation. Overruled.
Yes.
You indicated that you had the opportunity to review reports from other evaluators who met with Ms. Schabusiness and provided opinions in this case. Is that correct?
Yes.
Did you note whether or not any of the other evaluators shared similar concerns about the bipolar diagnosis assigned to her by Nicolay Psychiatric?
Yes, I noted that in Dr. Engen's mental responsibility evaluation, she took most specific and direct issue with the basis for that diagnosis, and she ultimately, in her report, offered that she did not see sufficient support to assign a diagnosis of bipolar disorder. I also noted that, for example, in Dr. Lucetta's competency report, while she did not necessarily completely rule out bipolar disorder, she also noted again that the substance abuse was a significant factor leading up to that diagnosis, and she merely essentially sought to rule out that diagnosis but did not assign it.
So I want to just sort of speak generally about bipolar. Can you describe for the jury what bipolar is and what is required to diagnose such a disorder?
Yes, and so there are two different types of bipolar disorder. There's bipolar 1 disorder, which is a more severe condition, and that is the diagnosis that has appeared in some of the records in this case. Bipolar 1 disorder is characterized predominantly by manic episodes, which are periods of it lasting at least a week where more often than not the individual has a significantly elevated mood. They may behave impulsively, erratically, have a decreased need for sleep. And in some instances with bipolar 1, that is alternated by depressive episodes, which typically last at least 2 weeks and are largely the opposite of mania. That means a persistently low mood, low energy, feelings of worthlessness, guilt, or hopelessness, things of that like. Whereas bipolar 2 disorder has hypomanic episodes, which are not as prolonged or severe as a manic episode. And by diagnostic criteria, someone must also experience depression in order to qualify for bipolar 2 disorder.
So is it fair to say that to diagnose someone with bipolar 1, we would have that expectation of seeing those prolonged manic episodes, at least one instance of a prolonged manic episode?
Yes, and it would need to occur outside voluntary substance intoxication.
Is it possible for a person who has been diagnosed with a bipolar disorder, is that the type of condition that could occasionally wax and wane over the course of someone's lifetime?
To the extent that someone does indeed meet diagnostic criteria for bipolar disorder, yes, there certainly can be a waxing or waning or a cyclical pattern of symptoms.
I also want to harken back to the fact that you have done NGI evaluations, is that correct?
Yes.
And is bipolar a condition that can sometimes contribute to an opinion that someone does meet NGI criteria?
Yes, it certainly can.
And under what circumstances might you expect to see that?
Yes, and so in order to reach an opinion of supporting an NGI plea in the context of bipolar disorder, one, there would need to be a firmly established diagnosis of bipolar disorder, again, in the absence of substance intoxication, and there would need to be a very direct linkage between the symptoms of that mental illness at the time of the alleged offenses and the substantial lack of capacity to either appreciate wrongfulness or to conform conduct to the requirements of the law. It's not enough for the defendant to simply be symptomatic, but that linkage needs to be established with the lack of capacity.
When you talk about establishing that linkage between the crimes alleged and the mental illness that's been assigned to an individual, what sorts of facts or circumstances do you consider when you do NGI evaluations?
And so there would need to be converging data sources indicating that indeed the defendant was symptomatic of that legitimate mental illness at the time, and there would need to be, conceptually, it would need to make sense for the alleged misconduct. There would need to be some sort of reason that mania, for instance, would have caused that behavior. There would need to be evidence to suggest that the person was fundamentally unable to control their behavior. And so again, that would typically comprise a pattern that extends beyond that one momentary act, but it would need to be a broader pattern encompassing that time frame.
So if you are evaluating whether someone's bipolar disorder might be causal of the criminal offenses, would it be significant to you to evaluate the defendant's symptoms or how someone presents immediately before and immediately after the alleged offenses?
Yes, those would be critical time frames in which to gather as much data as possible.
Is that because one would expect that someone with bipolar wouldn't manifest those symptoms solely for a short period of time, but typically over a much longer period?
Yes, that is correct.
Objection calls for speculation.
I think it calls for his professional opinion.
Overruled.
Yes, it would be expected to see, again, a symptom duration longer than just the mere moments of committing a criminal offense.
Doctor, I want to quickly return back to some of the other records that had been mentioned. You indicated that you did have an opportunity to review the medical records from Bellin Health from two different stays that Ms. Schabusiness had, one in 2012 and one in 2014.
Yes.
And I'll first call your attention to the 2012 records, if you recall those. Do you remember if Ms. Schabusiness was assigned a diagnosis by the treatment providers at Bellin Health at the outset of her stay in 2012?
She was assigned a diagnosis of mood disorder not otherwise specified.
So she was not assigned a bipolar diagnosis at that time, is that correct?
Correct.
And then in 2014, did she likewise have some sort of diagnosis following her 3-day stay in Bellin?
She was again assigned a diagnosis of mood disorder not otherwise specified, and they did add, which is not a diagnosis per se, but they noted alongside the diagnosis a history of psychosis. But in looking closer at the records, that history of psychosis derived squarely from an adverse medication reaction, which prompted the initial inpatient stay. So she was prescribed sertraline, and then only after that did she begin to have psychotic symptoms, and those symptoms resolved as soon as that medication was discontinued.
Again, she was not assigned a bipolar diagnosis in 2014 either.
Correct.
Dr. Seipel, you indicated that you did have an opportunity to review Dr. Litton's report from July 3rd of 2023.
Yes, I did.
And what type of report from a forensic standpoint was Dr. Litton's report?
It appeared to be a combined competency and NGI report.
In your experience and training, is it best practice for someone to engage in a combined report of both competency and NGI?
Typically, a separate report would be submitted to address each issue independently.
What are some of the reasons why you might not combine those two reports?
For one, there can be information introduced in the issue of criminal responsibility that might be inappropriate to be contained within a competency report. A competency report is not supposed to contain incriminating information with regard to the alleged offenses. but also and from a psychological standpoint, it makes it difficult to parse out which data and which arguments are directed at each respective issue if they're addressed alongside each other in the same report.
Is it particularly concerning if you come to a conclusion that a person is not presently competent, that you would also rely on that information to form an NGI opinion?
I would say that it's not inappropriate if that's a data point that is considered, but that there should not be a strong linkage in that reasoning, as again, it's two different legal issues pertaining to two different time points.
Doctor, when you looked at that report as it relates to NGI and Dr. Litton's report, I'm just going to ask you generally, did you have any concerns with the methodology that was shown in that particular report?
I found that it seemed appropriate data sources were consulted, at least that's what the methods section suggested in that report, although there was essentially no discussion or review of the discovery materials that were reviewed, and really no account from a defendant's perspective of the alleged misconduct, which are very critical pieces of information that would always be included in an NGI report.
So those pieces of information that you just discussed, like the account of the offense and the specific discovery materials outlining the offense, why is it important to include that type of information in the report?
Because again, the statute for NGI pertains squarely to the moments of the alleged offense, and that is the data that most directly captures those moments. And so it becomes somewhat of a black box issue if those moments are not discussed in the report and inferences instead are appearing to be made based upon presentation at other time points. That's not sound professional reasoning with regard to the issue of NGI.
And I want to talk about information being based on other time points. Did it appear to you that Dr. Litton relied very strongly on her personal observations of Ms. Schabusiness in the interview?
I would say it seemed that the symptoms that were portrayed during the moments of that interview seemed to weigh heavily, as well as the mere fact of a bipolar diagnosis being assigned roughly a year before the alleged offenses.
Were you able to determine whether or not Dr. Litton actually assigned a diagnosis herself?
It seemed implicit in the report that she concurred with the bipolar diagnosis, although it was not explicitly stated. For instance, I am assigning the defendant a diagnosis of bipolar disorder.
Is that typical in your experience to not assign a diagnosis during such an evaluation?
In an NGI evaluation, as the identification of a qualifying mental disease or defect is critical and necessary to support an NGI plea, it would be essential for the diagnosis to be very explicitly indicated.
And that was not done here?
I would say, again, it was not explicit, rather it was more so inferred, being embedded in text.
And Doctor, the report from Dr. Litton, does that include a relatively lengthy or specific discussion of the observations of Dr. Litton from the interview that occurred in June of 2023?
Yes, the greatest detail seemed to pertain to that which would have been her second contact with the defendant.
And you personally had contact with the defendant within about a month of that particular interview. Is that fair?
It would have been roughly like 3 or 4 weeks per my estimation.
The observations that Dr. Litton is making of the defendant, her actions, her behaviors, her psychotic state, did you witness those same things when you met with Ms. Schabusiness?
I did not notice the evident distraction that was evidently apparent during the interview with Dr. Litton. The defendant easily maintained focus and was able to supply coherent, relevant responses to questioning. She remained behaviorally appropriate and was able to engage in detailed discussion of her legal situation. There was a brief moment in which she referenced claiming to see a supposed green train within the room, which is something that was evidently very distracting during the interview with Dr. Litton. I essentially ignored when that symptom was mentioned, and there was no further mention of it thereafter, and there was no evidence that she was in any way distracted by that or any similar psychotic symptom.
Did you form a conclusion with respect to the psychotic manifestations that Ms. Schabusiness was outwardly claiming to have?
I found that there was not sufficient support for assigning a diagnosis such as bipolar disorder or schizophrenia that could presumably underlie those symptoms.
Did you have any concerns about the validity of the claimed symptoms?
Yes, I did.
And what were those concerns?
And so my concerns were manifold. There has been a remarkable inconsistency in presentation over the pendency of this case in terms of the symptoms the defendant has claimed to forensic examiners versus to clinical providers within the jail. And even during very similar time frames, she's offered contradictory remarks. And apparently, only during the interview with Dr. Lighton has anyone observed her during the pendency of this case to seem to be preoccupied with internal stimuli. That's not something that I have observed, and jail providers have noted that even in the isolated instances where the defendant has endorsed hallucinations, they have viewed no outward indication.
I would object only because that calls for hearsay. I apologize, but overruled.
I forgot where you were in your answer, but if you're...
Ask another question.
Sure. Had other doctors who evaluated the defendant shared concerns that you reported about the possibility of feigning or embellishing symptoms?
Yes.
And who was that?
I noted that first in Dr. Lucetta's competency report as part of a competency instrument that she administered to the defendant. Embedded within that were validity indices. That means there were testing items which sought to determine the credibility of the defendant's endorsement of psychiatric symptoms. And her responses to those items suggested an elevated probability of a non-credible response style with regard to endorsing psychiatric symptoms. And similarly, when Dr. Engen completed her NGI evaluation, she administered the Minnesota Multiphasic Personality Inventory, or MMPI as it's widely known, and the extent of her invalid responses on that instrument made it where her clinical profile could not be interpreted because the validity skills for that instrument suggested she was grossly exaggerating psychiatric symptoms in a manner that would be extreme and inconsistent even for a patient with legitimate schizophrenia.
And did you note whether or not Dr. Lighton performed any such psychological testing to determine the validity of the symptoms that she was observing from Ms. Schabusiness?
I found no mention of any type of instrument for symptom validity within her report.
Was that surprising to you?
I would say yes in general, but especially specifically given that those psychotic symptoms really seem to be the crux of her opinion regarding the issues of both competency and criminal responsibility, and especially in light of prior testing data that cast significant doubt over the legitimacy of those symptoms. So under those circumstances, it would be extremely unusual for an examiner to not administer testing.
Now, did you administer testing of Ms. Schabusiness when you met with her?
I was prepared to administer testing upon entering the evaluation, although her clinical presentation suggested such testing would not be necessary to reach an opinion regarding her adjudicative competency.
Can you explain that maybe just in a little more layman's details?
Yes, and so to the extent that the defendant would have presented similarly as she did with Dr. Lighton, for instance, presenting herself as very distracted by hallucinations, unable to supply linear or coherent responses, then I would have administered psychological testing to see where the validity lied with such symptoms. Although she did not portray those symptoms and with relative ease was able to discuss her legal situation in a rational manner, so the validity of symptoms became a moot point. That the results of that testing would have had no influence on my opinion regarding competency.
Essentially, you didn't need to test the validity of the symptoms because you didn't see the symptoms.
Correct.
Now, Doctor, you also had an opportunity to review the report of Dr. Engen, which I believe you previously mentioned. Is that right?
Yes.
Now, Dr. Engen's report is a report on NGI and not competency. Is that right?
Yes, it is specifically and solely to the issue of NGI.
Now, some of the shortfalls of Dr. Lighton's report that you already pointed out, did you see those same concerns in the report of Dr. Engen?
I did not.
Can you compare or contrast the methodology that Dr. Engen used to the methodology used by Dr. Lighton?
And so in Dr. Engen's report, I found to be consistent with my training, experience, and my understanding of best practice in the field of forensic psychology, and that she engaged in a thorough review and detailed in her report the discovery materials. She supplied a detailed accounting of the defendant's personal account to her of the index offenses. She reviewed medical records from the Nicolay Psychiatric Treatment Center that again would have been in that time period leading up to this offense, and she administered psychological testing to aid in determining the validity of any of the psychiatric symptoms that the defendant claimed during the evaluation. And so that represented to me a full and comprehensive NGI evaluation.
And in contrast, did Dr. Engen's report specifically tie Ms. Schabusiness's behavior at and around the time of the offense to any mental illness or lack thereof?
Dr. Engen supplied a detailed articulation of why she ultimately did not assign a qualifying mental disease or defect diagnosis to the defendant, and then she in turn articulated why she did not believe there was any support for the conclusion that outside of voluntary substance intoxication, the defendant would have substantially lacked capacity to appreciate wrongfulness or conform her conduct to the requirements of the law.
I think we touched on this earlier as it related to general diagnoses of a mental health condition, but can you talk briefly about the impact that acute substance intoxication has on attempting to determine whether or not someone would be NGI?
And so according to the Wisconsin jury instructions, mental disturbance brought on by voluntary substance intoxication is not considered to be a qualifying mental disease or defect. And so to the extent that an examiner cannot rule out the sequelae of that voluntary intoxication as being the primary contributing factor to behavior, then the reason would dictate that an NGI plea cannot be supported.
Thank you, Doctor. No further questions at this time.
Cross-examination, Mr. Freilich.
Thank you, Your Honor. Dr. Seipel, good afternoon.
Good afternoon.
You prepared two reports concerning Taylor Schabusiness, correct?
Yes.
One in November of 2022 and then one in July of 2023, correct?
Yes.
And you received police reports, correct?
I did not review the police reports.
Okay. Did you review the criminal complaint?
Yes.
Did you have a chance to review any video footage from the incident on February 22nd or February 23rd of 2022?
I did not.
In this particular case, did you administer the two gold standard tests, the MMPI and the MCMI?
I did not administer either of those instruments.
Okay. Yet you criticized Dr. Lighton for not doing it, correct?
Yes.
Now, you've been a licensed psychologist since February of 2022, correct?
Yes.
That's when you obtained your license to practice and do evaluations and reports and all of that, correct?
My license enabled me to practice independently, although I performed all of these evaluations under supervision from September 2020 up until that time.
Okay. In September of 2020, that's when you were a fellow?
That's when I began my postdoctoral fellowship in forensic psychology.
Okay. When you've had a chance to review Dr. Lighton's curriculum vitae, correct?
Yes.
You've had a chance to review her evaluation from July 3rd of 2023, correct?
Yes.
As far as experience level, she has more experience than you, is that fair?
I would say she's been a practicing psychologist longer, although the extent to which she has conducted NGI evaluations, I don't know if she has more experience than me.
You understand that she worked at Mendota Mental Health in the past, correct?
Yes, and typically NGI evaluations are not performed for patients already within the State Mental Health Institute.
And with regards to Dr. Christina Engine, she works in the Wisconsin Forensic Unit as well?
Yes, she is employed by behavioral consultants in the Wisconsin Forensic Unit.
Would she be a colleague or a coworker of yours?
I would say we are similarly employed, although we practice typically in different areas of the state and have pretty minimal contact with each other.
And the two of you are aligned as far as opinions in this particular case, is that fair?
Well, we opined on different issues, so I would not agree with that statement.
But the ultimate recommendation is the same, correct?
I guess I'm not sure what you're asking, sir.
That you and her both find insufficient evidence to support the special plea, the NGI plea.
I would say I did not offer an opinion with regard to NGI, so again, I can't agree with that statement.
Okay. You've had a chance to review Brown County Jail records, correct?
Yes.
You reviewed Bell and Health records that I sent, correct?
Yes.
You had a chance to review the Nicolay Psychiatric Center records through Brown County, correct?
Yes.
You reviewed a lot of mental health records, correct?
Yes.
Fair to say that Taylor Denise Schabusiness does have a mental health history. Would that be fair?
I would say in general terms, yes, she has had contact with mental health treatment.
And fair to say that she was the subject of a civil commitment in 2021, correct?
Yes, it is my understanding that she became subject to a 6-month civil commitment during the course of her inpatient treatment in 2021.
And she was found by a court of law to be mentally ill, at least in 2021, is that fair?
According to that court order, it would suggest that, yes.
And then she was on a medication order in order to take psychotropic medications for that same period of time, correct?
Yes, it is my understanding she was court ordered to medication compliance.
A lot of different doctors evaluated and took a look at Ms. Schabusiness, correct?
With respect to the pendency of this case or more generally?
Just with respect to the pendency of this case.
Yes, I would say there have been a handful of us that have completed evaluations.
Dr. Deborah Collins? Yes?
Yes.
Dr. Tracy Lucetta?
Yes.
Dr. Diane Lighton?
Yes.
Yourself?
Yes.
Dr. Christina Engine?
Yes.
With regards to Ms. Schabusiness's treatment at Nicolay Psychiatric Center, was she diagnosed over there in May of 2021 with bipolar disorder, current episode manic severe with psychotic features?
Yes, that was the diagnosis those providers assigned.
She was prescribed medications, correct?
Yes, I believe it was an antipsychotic medication that was prescribed.
Do you know if that was Aristotle?
I would have to consult the records to refresh my memory.
Was it your understanding that she was prescribed a medication that would be by injection?
To the extent that it is Abilify Aristana, yes, that is a long-acting injectable medication.
It's an antipsychotic medication, correct?
Yes, with mood-stabilizing properties as well.
And fair to say that through Brown County, through Nicolay, that Ms. Schabusiness was given a diagnosis of bipolar disorder.
Yes.
She was at Nicolay for about a month, correct?
I believe it was roughly 3 weeks.
A couple weeks, and then she was discharged?
Yes.
She was discharged, you know, after she had her baby?
What was the question, sir?
Do you know, I'm sorry, do you know if she was discharged after she had her baby?
I do not believe she gave birth during the course of that hospitalization.
Subsequent to that, she gave birth, correct?
I would again have to consult the records for the dates on that.
When you looked at all these records, did you come to find that there were some references to Ms. Schabusiness suffering from paranoia?
That word was mentioned in the records on some occasions, yes.
And was it mentioned that she had experienced some delusional thoughts?
Again, that was a word that has been used in the records, yes.
And was it mentioned in some of these records that we're talking about that she did suffer from distractions, inability to focus or concentrate?
Yes, there were some notations of those concerns as well.
Was it such that, in gleaning through the records, analyzing them, that she had auditory or visual hallucinations on occasion?
Yes, and most specifically that first admission to Bellin, as well as the admission to the Nicolay Psychiatric Center where I saw the hallucinations mentioned.
Was that mentioned in 2021?
Yes, upon her admission to Nicolay when she had heavily been abusing methamphetamine recently.
You've been a doctor for some time. You've got a PhD. You've got a lot of education. You've had experience with different kinds of patients, correct?
Yes, many, many different kinds.
With all different sorts of problems, correct?
Yes,
And you've dealt with people who have had drug addictions and things of that sort, correct?
yes,
You've gone to seminars with regards to how substances can affect the brain, correct?
yes, and I taught an undergraduate course regarding the effect of substances on psychology as well.
Wow.
And would it be fair to say that substances can impact the brain, can cause organic brain damage?
I would say there can certainly cause some functional abnormalities in the brain, although the notion that drug use permanently damages the brain really is not consistently bore out in the literature the way that it is in kind of the public conception of drug use.
Drug use can also exacerbate mental health problems, correct?
It can exacerbate them or cause them of their own accord, yes.
What causes memory impairment?
There can be manifold causes for memory impairment.
Drug usage?
Certainly if there has been recent and especially significant drug use, yes, that can affect various neurocognitive capacities, including memory functioning.
How about traumatic events like loss of a mother?
I would say that can cause some difficulties with concentration, though typically would not cause amnesia in and of itself.
Is PTSD, post-traumatic stress disorder, is that a mental health condition?
Yes, it is.
Can that get worse over time if untreated?
It can, yes.
If someone has a mood disorder, is that a mental health issue?
Yes.
It's a mental defect or a mental disease?
I would say it could meet criteria as a mental disease or defect according to Wisconsin state statutes, yes.
And can that get worse over time, the mood disorder, if it's left untreated?
It can, yes.
People are not subjected to a civil commitment order unless they have a mental health condition, correct? Is that fair?
It would require a clinician to opine that they have a mental illness, yes.
Wow. This guy is tight. His mind works pretty quick.
I saw some records in Brown County. I believe it relates to the Nicolay Psychiatric Center records, that there was a problem addressed, risk for self-injury related to delusional thought process vague. Do you know what that references to?
I believe I recall seeing that verbiage in the records, but I wouldn't be able to supply context without reviewing those records.
Do you know if Ms. Schabusiness had problems or issues with a delusional thought process?
At that time, it was noted that that was a symptom she was displaying upon admission to the facility, yes.
Did you have occasion to, when you met with her, to observe that she had a tangential thought disorder?
During my meetings with the defendant,
Yes.
I did not note signs of a clinically significant thought disorder, no.
How about, was that bore out with Dr. Engine or Dr. Collins?
I would say there was, again, no indications of clinically significant impairment in maintaining linear thought during those evaluations.
In your review of the Brown County progress notes from Nicolay Psychiatric Center, did it have references to Ms. Schabusiness identifying demons in her life?
In terms of the Nicolay psychiatric records,
Yes.
I do believe there was mention of some commentary of that sort, yes.
And was there commentary that her affect appeared to be labile and inappropriate throughout group, and that she had mood changes and inappropriate facial expressions or laughing?
Yes, I did see that bore out on those records.
Did you see that when you talked with her in November of 2022 or July of this year?
I did note that there were some moments of some inappropriate grinning or perhaps very brief isolated instances of laughter. All those were short-lived and did not impair capacity for us to have a linear and meaningful discussion.
In July, when you met with her, you said 90 minutes, give or take. Was it cut off for any reason? Was your interview cut off?
No, they were able to be completed on both occasions to their natural course.
In some of the records, did you note that it indicated her affect was flat when approached?
Yes, there were some indications of a
Was it cut
relatively
off?
flat or diminished expression in her emotional presentation, yes.
What does that stem from, do you know?
That's again something that can have manifold causes and could simply be someone's baseline emotional presentation as well.
Could it be related to a mental health defect or disease?
It is possible, although again, it could also be due to many other factors.
Also in these progress notes, did you indicate, or did you review, that she was feeling as though different bodies were going in and out of her person?
I do believe I read that in the Nicolay notes as well, yes.
Did she talk about having pressure in her head or having her head hurt?
Yes, that is a complaint that she has made at different occasions across time, yes.
And did she also indicate that she had problems with eye twitching and that her PTSD was triggered from loud noises?
I do believe I recall seeing those symptoms mentioned in the records as well.
Did you, at least in some of either the jail records or the Brown County records from Nicolay, that she talked about wanting to die and go to heaven to see her mom?
Yes, I do recall seeing such comments made.
And in reviewing these records, because there were a lot of them, did she indicate, at least in the records when she was at Brown County at Nicolay, that she was hearing voices that would get heavier at night?
I do believe, yes, there was a pattern of time of day seeming to impact symptoms at that time, yes.
And the time of day would be more at night, they'd be more pronounced at night than the daytime?
Per my recollection of the records, I do believe that was the pattern that was mentioned.
And she was encouraged to connect with a dual therapist to address mental health and her AODA issues. Is that fair?
Yeah, consistently over time, she has been referred for substance abuse treatment, yes.
And in those records from Nicolay, it also talked about that she would have racing thoughts that would get overwhelmed and that she'd hear voices in her head.
Yes, those are symptoms I do recall seeing in the records.
It's true, right, that there were discussions about her getting this Aristata injection every 4 weeks to help her?
Yes, that is the typical course in which that medication is administered, and per my recollection, I do believe that's what was ultimately prescribed.
Then there was some discussion about whether she would take the pill or take the injection, correct?
Yes, I do believe that the means of administration was discussed amongst her clinical team.
Even in the notes, it talked about, in the notes from Brown County, from Nicolay Psychiatric Center, it talked about how Ms. Schabusiness would have agitation, anxiety, correct?
Yes.
And that there was a discussion about giving her Haldol, correct?
Yes, that would be another antipsychotic medication with pretty heavily sedative properties.
Do you know if that was ever given to her?
I would again have to refresh my recollection with the records.
And even in the Nicolay records, it talked about that it was a struggle to decipher what is a genuine psychiatric symptom and what is otherwise talked about as gaminess, correct?
Yes, I do believe that was a term that was employed in the records.
There were just a lot of records to review, and you have a good memory. But it also talked about Zoloft, correct?
Yes, that was mentioned specifically in her adolescent treatment records.
And Ms. Schabusiness was given, apparently at Nicolay, from what you reviewed in these notes, what are her coping skills and what does she want to do to make progress with mental health? Is that fair?
I don't recall that specific information.
With regards to Dr. Lighton, she says that she believes that my client, Ms. Schabusiness, qualifies for the NGI plea based on a diagnosis of a serious mental disorder. You understand that?
Yes, that's what she wrote in her report.
And she opines that her serious mental disorder affected Ms. Schabusiness's ability to know right from wrong at the time of the offense, correct?
I would say it was relatively tersely worded, although that was what was suggested, yes.
And she also said that it affected her ability to control her behaviors. Is that fair?
Yes, that was the opinion that she reached.
You have a diabolically opposed opinion compared to Dr. Lighton, correct?
Again, I did not opine on the NGI issue.
Okay. All right. Thank you. Nothing further.
Redirect.
Just briefly, I think you were asked a great deal again about the records from Nicolay and the specific symptoms that were manifesting at that time at Nicolay. And do you know if Nicolay actually administered a blood test to determine whether or not there were substances in her system at the time she entered Nicolay?
There was either urine or blood screening performed for toxicology purposes, yes.
And she did test positive for methamphetamine?
It was methamphetamine and I believe also amphetamines and THC as well.
And did the Nicolay records show a marked improvement in her symptoms in the 3-week stay there?
Yes, there was a relatively linear trend over time towards psychiatric stability.
And while that might potentially be attributed to taking psychiatric medications, it might also be attributed to weaning off of the illicit substances.
I would say it's fundamentally impossible to disentangle to what extent precisely the improvement would have derived from those sources.
And you were asked questions about at points in time, did Ms. Schabusiness have potentially paranoia or hallucinations or things that could potentially be associated with psychiatric conditions or psychosis? Did anyone in any of the records that you saw make such an opinion on or around February 22nd and 23rd of 2022?
In terms of those symptoms or diagnoses applying at the time of the alleged misconduct,
Correct.
I would say that from what I saw, Dr. Lighton was the only one that, and again, it wasn't really directly discussed, though at least seemed to imply that those symptoms were at play at the time of the incident.
Now, none of the mental health records that you saw were from February of 2022, is that correct?
I did not see any indication of her being actively involved in psychiatric treatment, so there was no reliable collateral source to corroborate those symptoms at that time.
And again, just to clarify, I think you've done a good job of this, but you were not asked to opine on the issue of whether or not an NGI offense or an NGI defense is appropriate for Ms. Schabusiness in this case.
That is correct. I was only ordered as a competency examiner.
Thank you. I have no further questions.
On those topics, Mr. Freilich?
No, Your Honor. Thank you, Dr.
Thank you,
Seib.
Doctor. You can step down. State's next witness.
State calls Christina Engine.
All right, time to face the printer, the judicial printer, and take your oath. Make 3 copies of that right away.
Doctor, if you just step forward here, and then before you have a seat, if you could turn and face her and raise your right hand.
Face the
Place your
holy
right.
printer.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God. Yes. Please have a seat and state your name for the record.
Christina Engen, Christina Engen.
She looks
Mr.
serious.
Saunders, the witness is yours.
All right, Doctor, how are you employed?
As a psychologist with behavioral consultants,
And how long have you been employed with behavioral consultants?
12 years.
And do you have any degrees?
I do. I have a PhD in counseling psychology from UW-Madison, which I earned in 2010.
All right. And I guess what do you do as a psychologist with behavioral consultants?
I conduct almost exclusively criminal forensic evaluations.
And we've heard that term a few times. What is, forensic evaluations? What does that mean?
The court principals will approach a psychologist with a psycho-legal question, so a psychological question that applies to the legal situation, and our job is to help answer that and to provide information to the trier of fact, the judge or the jury, to help them answer that question.
Are some of those evaluations that you're asked to conduct what are referred to as NGI evaluations?
Yes.
And I guess, what does NGI refer to?
It's for the plea of not guilty by reason of mental disease or defect. It's an evaluation of criminal responsibility.
And
She literally just winked
you
at us,
have
bro.
performed those
Everybody saw
evaluations
that.
in the
Come on.
past?
It
Yes.
can't just be me.
Are you able to approximate how many NGI evaluations you've completed in your career?
Over the course of 12 years, approximately 250 NGI evaluations.
And are those typically done at the request of a court?
Yes.
Have you, in your career, in those 250 evaluations, reached an opinion that somebody would be appropriate for an NGI plea?
Yes.
And contrary, have you formed the opinion that they are not, they don't fit for the NGI plea?
Yes.
All right. And Doctor, do you maintain a curriculum vitae with respect to your educational background and qualifications?
Yes.
All right. Showing us in Mark Exhibit 12. Do you recognize that?
Yes.
And what is that?
It is my curriculum vitae.
And does that appear to be up to date?
Yes,
All right. That's a document that you prepared?
it is.
I'd move 12. Any objection?
No objection.
12 will be received.
Do you maintain any licensures?
Yes, I'm licensed to practice psychology in the state of Wisconsin.
And are you also board certified?
I am.
What does that mean?
I'm board certified by the American Board of Professional Psychology. Applicants can specialize in several different areas of psychology. My area of specialty is forensic psychology.
And do you maintain any professional memberships?
Yes.
And what are some of those?
With the American Psychological Association and the Wisconsin Psychological Association.
In addition to your employment, do you also, or have you had any teaching experience in this role?
Yes.
All right. And what are some of those?
I've provided guest lectures for Marquette Law School, for trainees at Mendota Mental Health Institute, once for the Department of Correction psychologists.
Doctor, then I want to ask you about this case. Did you become or asked to become involved in an NGI evaluation of Taylor Schabusiness?
Yes.
And how did you become involved in that?
I was court ordered to conduct an NGI evaluation.
Were you retained by the state of Wisconsin?
Appointed by the court.
By the court, but not the district attorney's office?
Correct.
And you weren't retained by the defense either?
Correct.
And is it's the case that most of the evaluations you perform are at the request of the court?
That is correct.
And did you ultimately prepare a report with respect to your findings regarding that NGI evaluation?
Yes.
Doctor, I'm showing you Exhibit 13. Do you recognize that exhibit?
Yes.
And what is that?
It's a copy of my report.
And does that contain your, I guess, factual findings and ultimately your opinions with respect to the NGI evaluation?
Yes.
I'd move 13.
Any objection?
Subject to cross, Your Honor, no objection.
13 will be received.
So I guess generally, can you describe the process that you undergo to conduct an NGI evaluation?
Yes, the evaluation consists of a clinical interview, so a meeting with Ms. Schabusiness. I also conducted a full discovery review, so review of all of the police reports, videos, documents of that. And then I also, in this case, reviewed her available medical records, which included a prior competency evaluation, records generated through Brown County, and then in this case, I did administer psychological testing.
Okay. So I want to first start with the clinical interview that you mentioned conducting. What date was the date that you met with Ms. Schabusiness?
So I attempted to meet with her first on October 12, 2022. However, because of her security status in the jail, I was not able to meet with her confidentially. So I returned on October 21, 2022, and we met in a conference room. That's when I conducted the interview and the psychological testing.
And October 21st, 2022, would that have been about 8 months after the offense that she was charged with?
Yes.
Okay. And you also mentioned you conducted a full discovery review, and that included reviewing videos. Is that right?
Correct.
Okay. Was one of those interviews that you reviewed an interview of Ms. Schabusiness from February 23rd of 2022?
Yes,
Was that a rather lengthy interview?
it was.
Did you review the entirety of it?
To the best of my recollection, I believe that I reviewed the vast majority of it. If I would say the majority of it.
All right. Were there a lot of dead parts in the middle of it?
Dead
There
parts,
were,
Brian?
but I thought it was important to review
Anyway, this comment
that
makes
video
sense to me.
footage to listen for comments that Ms. Schabusiness would have made in the room by herself to observe her behaviors and the like.
So it wasn't just the comments that were made to law enforcement that you were looking for, but also her independent behaviors?
Correct.
And you also mentioned you reviewed the police reports and other various attachments that were part of the case?
Yes.
The medical records that you reviewed, you mentioned their prior competency evaluations, but also Brown County Health Services records, is that right?
Correct.
Was that in reference to a stay at Nicolay Psychiatric?
Correct.
All right, and when was that?
That spanned March of 2021 to April 2021.
All right. And you then indicated you also conducted a, I guess, personality test, or what was the fourth collateral source you reviewed?
I can administered an objective personality test. It's called the Minnesota Multiphasic Personality Inventory, 3rd edition. The acronym is MMPI-3.
Okay. So I want to then go through your report, if that's okay, Doctor. Beginning on page 2. So one of the things you start with is called relevant history. Do you see that section of the report?
Yes.
And I guess why is it important to review the history as part of your NGI evaluation?
When gathering history about a defendant, we are touching on topics that are potentially relevant to the issue of criminal responsibility. Things like early childhood events, history of mental health treatment, substance use, any learning difficulties, difficulty working, all of this can potentially inform the issue of criminal responsibility.
Okay. And as part of that, did you review Ms. Schabusiness's employment history?
Yes.
And I guess what did you note with respect to her employment history?
What I recall is that she has worked primarily in factory settings. Relevant to this evaluation was that she was working up until about a week before the underlying offenses.
Why is one's employment history relevant to an NGI evaluation?
It speaks to the prong of behavioral control. So later on, when we discuss the prongs of the NGI plea, one of them has to do with one's ability to conform their behavior with the requirements of the law. It's a capacity issue, so can a person do that under normal circumstances? And one's ability to work, maintain employment, show up, perform their job duties, that speaks to an individual's capacity to conform their behavior and meet the demands of daily living.
Okay. And you noted employment history fairly consistently up to about, I think you said a week before the offense?
Correct.
And you also reviewed Ms. Schabusiness's mental health history as well?
Yes.
As we talked about. As well, did you review her, during the course of your clinical interview with Ms. Schabusiness, her current presentation?
Yes.
And I guess what is the importance of kind of noting, as you do, the current clinical presentation of a patient?
So that's another piece of information that informs the diagnosis that is required of the evaluation.
Okay. As part of the clinical interview with Ms. Schabusiness, do you get a narrative from her about the alleged offense?
To the extent that I was able, I did. Ms. Schabusiness recalled the time period leading up to the offenses, but then she reported that she had no memory for the offenses themselves, and she did not. She reported she did not regain memory until after her arrest.
Okay. With respect to Ms. Schabusiness recalling the time period leading up to the offense, what sort of information did she provide?
What I learned was that she had been living in Texas and returned to Wisconsin in early 2022 to tend to legal matters. She made a court appearance. I believe she was sentenced to 5 years probation. She was making arrangements to have her community supervision transferred to Texas so that she could resume caring for her newborn baby, who was in the care of her grandparents. She was working. She had started Suboxone treatment to maintain sobriety. And I understand that she struggled during this time period, was feeling what sounded like to me some alienation in the workplace. Not feeling like she was connecting with her coworkers, and then began to, she reported to me she was hearing voices that were telling her to relapse on methamphetamine.
Okay. And some of those, you mentioned, employment, you mentioned some arrangements with respect to childcare. Why are some of those acts kind of relevant from an NGI evaluation standpoint?
Again, it speaks to the issue of one's capacity to conform their behavior. So all of those are very goal-directed tasks.
And those were all kind of leading up to the date of the offense.
Correct.
With respect to February 21st, 2022 specifically, did she have a narrative about sort of the timeline of events leading up to the offense?
Yes, on February 21st, 2022, she recalled that she was socializing with friends. They had come to the residence she was staying in. I believe they were smoking marijuana. She expressed an interest in finding methamphetamine, and so she said that she went on a, quote, meth hunt, end quote.
Did she indicate whether she had ingested methamphetamine leading up to the homicide?
Yes, she told me that she took 52 hits of methamphetamine.
And did she also refer to that amount as, quote, a lot?
Yes.
All right. And did she indicate at some point that night meeting up with the crime victim, Mr. Therian?
Yes,
And then you indicated around the time of the alleged offense, she reported having no memory of that time.
How do these
Correct.
people afford all these drugs? Come on.
Did she, and then you indicated she regained her memory sort of in speaking with law enforcement.
Very
yes.
strange.
Was that professed amnesia of a concern to you?
It was notable. As I indicated in my report, I found her self-reported amnesia to be inconsistent with my review of the discovery material. So specifically, I observed her describe in great detail to the detective the details of that evening. So that stands in contrast to her self-reported amnesia in the present or at the time of the October interview.
You also indicated during the interview with Ms. Schabusiness, you performed some psychological testing, is that right?
Yes,
What testing did you administer?
it was the MMPI-3.
What is the MMPI-3?
It's a very well-established psychological instrument dating back to the 1940s, very well-researched and respected. So this test can provide indication of different types of psychopathology or different types of mental illness. It also contains a number of validity indices to help psychologists understand the response style of the test taker.
So the validity indices, I think I said that right, that you mentioned, I guess, what does that mean?
What that means is that built into the test are several items that, when they're all combined at the end, they'll indicate if a person is answering questions in a forthright manner, if they're minimizing their symptoms, or potentially if they're exaggerating their symptoms.
So is this test like a true-false questions, or how does this test administered?
Correct. It's a true-false instrument.
And I guess what were some of your findings with respect to Ms. Schabusiness's performance on the MMPI test?
Well, first, let me be clear that the test does not say anything about Ms. Schabusiness's functioning. In February of 2022, it only provides information about her functioning at the time of the test. So what was relevant from that was that there was indication of symptom exaggeration. She responded to items, she endorsed a number of symptoms that individuals with genuine mental illness would not endorse. The frequency, number of unusual symptoms that she acknowledged was greater than those with genuine mental illness. And then there was also indication of non-credible memory impairment built into those, the results of those validity indices.
So I just want to go back a little bit. Those are good points. So this testing is sort of in the moment as you're meeting with Ms. Schabusiness, is that right?
Correct.
But why is it still something you administer in the course of an NGI evaluation?
So getting back to that term of response style, that's very important to understand if the individual is being forthright in their account of information that they provide to me. And what I found with these elevated indices indicating the exaggerated descriptions of mental illness, unusual descriptions of mental illness, is that the information that was being reported to me needed to be interpreted with caution. Ms. Schabusiness's self-report could not be taken at face value.
And I think you state that anything that's not objectively observed should be closely scrutinized, is that right?
Correct. So then it would be important to find other sources of information that would support what she's telling me versus relying just exclusively on her self-report.
Okay. And one of the phrases you used was endorsed symptoms. What does that mean?
For example, I'm just making this test example up, but I feel depressed. a true response would be an endorsement of that symptom.
So an endorsement is something somebody's telling you.
Yes.
All right. So based on the interview you had with Ms. Schabusiness, your review of some of those collateral sources of information, were you able to offer an opinion with respect to whether Ms. Schabusiness was suffering from a mental disease or defect?
Yes.
And what was, I guess, that opinion?
I reached the opinion that while she did have a mental health conditions, these did not appear to qualify as mental diseases and defects.
In your report, you outlined, I guess, 3 mental health conditions. Is that right?
Correct.
What are those?
The diagnoses that I offered were methamphetamine-related use disorder, and that was applied in acknowledgement of Ms. Schabusiness's general use of methamphetamine in that time period. The diagnosis of methamphetamine intoxication was applied because she was using methamphetamine at the time of the crime. And then the final diagnosis I gave was methamphetamine-induced psychotic disorder. And I offered that one because Ms. Schabusiness was describing, and the records contained indication of paranoia. I think she made a comment about muscle rebuilding during the homicide, and this indicated to me the presence of psychotic symptoms, which I attributed to the recent methamphetamine use.
So, and that's a question I have. So mental health conditions, in your opinion, are different from mental diseases or defect?
Correct.
And the 3 diagnoses you offered, you stated those are not mental diseases or defects.
That is my understanding.
And why is that?
Because, excuse me. So if one ingests an intoxicant voluntarily, so they took it of their own volition, and if they were not naive to its effects, that would mean it's my understanding, based on the case law, that the defendant would be subsequently responsible for all alterations of thinking, judgment, behavior related to that intoxication.
I guess, were you aware of any information in the materials you reviewed that Ms. Schabusiness's methamphetamine use was anything but voluntary?
No.
And that obviously she reported a history of using methamphetamine to you?
Yes.
So I guess, were you of the opinion that she was not naive to its effect?
Correct. Yes. And I'm also aware that she had psychotic symptoms in the context of methamphetamine use the year prior. So certainly she was aware of its effects, broadly speaking, to include psychosis.
So I want to pause just here. Methamphetamine use in general, I guess, in your experience and in your education training, are you aware of some of the symptoms that may manifest as a result of that?
Yes.
And what are some of those?
Excessive energy, decreased need for sleep, and then oftentimes we see in the field of forensic psychology that it can induce psychotic symptoms. So misperceptions of reality, and paranoia.
You also mentioned a year prior there was a diagnosis of at the Nicolay Psychiatric Center. Is that right?
Yes.
And did you consider, I guess, the applicability or the appropriateness of a bipolar 1 disorder?
I did.
And what was your conclusion with respect to that propriety of that diagnosis?
After considering the diagnosis of bipolar 1 disorder, I did rule it out because I am aware that being intoxicated or having a methamphetamine-induced psychosis can look virtually similar or indistinguishable from a manic episode with psychosis. So the two look similar. And so what I would be looking for if I were to support a bipolar 1 disorder diagnosis is the presence of that psychosis and the mood elevation when there's no methamphetamine use present.
And are you aware of any of those symptoms absent in the context of methamphetamine use?
I am not aware of a time ever that Ms. Schabusiness displayed psychotic symptoms or elevated mood outside of the methamphetamine use.
And I guess you are aware, though, that bipolar 1 diagnosis was applied to Ms. Schabusiness in April of 2021.
Yes,
Are you aware, though, that there was concerns about recent methamphetamine use around that same time?
yes, I believe that she tested positive for several drugs, including methamphetamine at that time.
So that's why that's not a diagnosis you are willing to give to Ms. Schabusiness.
Objection leading.
Just clarifying the testimony. I'm just clarifying the testimony, Your Honor.
Overruled.
Thank you. So I guess in sum then, is there any mental disease or defect that you would diagnose Ms. Schabusiness with?
Yes, also offered at Nicollet, I'm not sure the pronunciation. There was a diagnosis of, I believe it was polysubstance abuse or something to that effect, meaning multiple substances were being abused at that time. I believe that's an appropriate diagnosis for her. I do believe I believe firmly in the diagnoses that I offered in my report.
Okay. But those are not diagnoses that I guess are mental diseases or defect.
Correct.
Okay. Did you also then reach an opinion with respect to the, I guess, second question or the second part of the NGI evaluation, whether she was responsible for the conduct?
Yes.
All right. And what was that opinion?
I found insufficient support for the conclusion that as a result of a mental disease or defect that she either A, was unable to conform her behavior to the requirements of the law, or B, was unable to appreciate the wrongfulness of her conduct.
What are some of the reasons you reached that conclusion?
Well, first, and most importantly, I was not able to find support for a diagnosis that would qualify as a mental disease or defect. So really at that point, then the analysis could end. That's a requirement of the plea. But I found, in my report, I outlined various different factors, but focusing on the two issues, one's ability to conform their behavior to the requirements of the law and one's ability to appreciate wrongfulness. First of all, I did pull from her behavior outside of the moments of her known intoxication to observe that she was able to engage in very goal-directed behavior. So I assumed that any alterations in her behavioral control were directly related to the methamphetamine use. So that was the first issue. And the second issue having to do with wrongfulness, it was my opinion that she did demonstrate appreciation of wrongfulness. There were several comments that were made to law enforcement expressing apologies to the victim's sister, indication that she was trying to conceal the body was dismembered because she wanted to conceal it. These all speak to awareness of consequences, appreciation of wrongfulness, that she grasped wrongdoing had occurred.
And did you also consider, I guess, the validity of the professed amnesia for the time surrounding the offense?
Yes, I did not find the self-reported amnesia to be credible. First of all, there was that disconnect between what she was reporting to me in the interview as compared to the recollection she had during an interview with the detective immediately thereafter. And then I also found indication in the results of the MMPI-3 that she was not, that she was reporting non-credible memory impairment.
do have just a few more questions, Doctor. Your report was done in November of 2022, is that right?
Yes.
And subsequent to that time, have you had the chance to review any other NGI evaluations conducted in this case?
Yes.
And who authored those reports?
Diane Litton?
Okay. And in your review of Dr. Litton's report, did any of her findings or conclusions alter your opinion from November of 2022?
No,
I guess the same opinions you're testifying here to today?
it did not alter my opinion.
Okay. And then all of the opinions that you're offering here today, are they to a reasonable degree of professional certainty?
Yes.
Thank you, Doctor. Nothing further, Your Honor.
Cross-examination, Mr. Freilich.
Your Honor, would we be able to take a break right now or not?
Okay. Ladies and gentlemen, we'll take a 10-minute break, and we'll resume. All rise for the jury. And Doctor, you can step down. We'll be in recess then for 10 minutes. I'd like the attorneys to return. Obviously, 10 minutes is a little bit before 3. I'd like to hear a little bit before 3 so I can speak to you a little bit about these instructions, okay? So we're in recess. Thank you.
So yeah, it does look like they have some kind of restraining belt on her, under her clothing. I think that was reported, something I saw. So while we've got this countdown going, let's hit a little bit more of on the topic of what happens, which we did at the beginning of this stream. But anyway, if the jury doesn't buy that she's insane, under the necessary findings they have to do for the legal definition of that, you know, that she had a mental disease or defect, it kept her from knowing right or wrong or created this compulsion. And she has the burden of proving that. So if she can't do that, then they return the verdict of no, she's not insane. Then she goes to prison. But what if they go, yeah, she was insane at the time of the crime? Then she's going to be committed. And committed means different things. Normally on the street thought you would be, well, she's shoved off to an institution for treatment. And it can mean that. But commitment under their law means that you're in an institution or you're released to the community, but under conditions and treatment in the custody of the Department of Health Services there. So the judge, if they want to put you in the institution, has to do certain findings, which would be no trouble at all in this case. And if she were to be found insane, she would be institutionalized. There's really no question about that any more than there was a question of whether she did the crime or not, because she's so dangerous. Now, once somebody is put in the institution, the commitment period can be for the length of the original prison sentence that this person was facing. But it doesn't mean that they stay in the institution until all of that's over. At some point, if they can get the support of the people that are treating them and they can defeat the state's contention that they're still dangerous, they can do a petition for conditional release. And then a judge would hear that and determine whether she's still a danger to herself or others. And if not, then in theory, you would be released upon conditions. So you'd have maybe during the day some or whatever it is they want to do with you. And in theory, the commitment could be terminated at some point, but you know, you could bet that if somebody's in an institution first, they're going to have to do some conditional release for a while. So I'm not suggesting that she would get out right away if she were institutionalized, because I do not think that. Even though the burden's on the state, she has proven to be so dangerous, it's really going to kind of shift to her to ever show that if she were to be found insane. So I'm not suggesting that going to a mental hospital is not, or is a fun time, because it's not, or that it's easy to get out of it when you've done the acts that she's done. It's not. I'm just telling you what the law is, because I've seen some people saying some things that are different than that. Now, if she is found insane and she goes off to the mental institution, she becomes a client, not a criminal. And so if she were to be found appropriate for release under conditions or something like that, she doesn't face a criminal penalty after this if she were found insane, because she'd be excused from responsibility. So let's see. let's see what's going on. I think when you I see a question here, did the judge say disruptions? I actually think he said jury instructions, or at least that's what I heard. Go over some jury instructions with you. So if I gathered the commentary earlier correct between the judge and the attorneys in this case, if he was going to give maybe some preliminary jury instruction to the jury before closing and then other jury instructions to them after that. I don't think there's a ton of instructions at this point. And it looks like they're near the end of the evidence. So if this is the state's last witness, there's cross-examination left. That's it. If the defense doesn't have rebuttal, and I don't think they will, then it'll be up to the judge to decide, do we do the closing statements today or not? I think he's ready to go with the jury instruction. So if they get along on that, maybe they will. I don't know. It's getting a little late in the day, but closing probably won't be very long on each side, right? And so I don't know. The case is going pretty fast. But if he sends it to the jury today, they can deliberate, I suppose, if they want to. But it's also possible, that they just say, I'm going to let you go early today. Come back tomorrow. We'll do the closing. You'll get the case, and you can deal with it. And then it'll probably be over by lunchtime, one way or the other, I think. So, see a lot of talk about kids in the chat. That's a subject I stay away from, even though our family's heavily involved in that, in terms of or at least particularly my wife, in terms of the treatment of kids with her positions at state and national level. She sees it all, and the landscape has certainly changed. So I'm checking to see if anybody's got any questions on the law stuff, if I happen to know the answer. I listened to it this morning, the case, and then looked up some things and showed that at the beginning of this stream. Let's see. So, of course, they had a ton of evidence against her in this case, including her own confession, which was allowed in testimony against her. And to me, she is definitely mentally disturbed, right? You can say she's crazy if you want to. You can say she's insane if you want to. I wouldn't disagree with any of that. The question is whether she's legally insane. And that, of course, I think everybody in the chat's got it. It comes down to whether whatever mental condition she has at the time of the crime was driving her to not know the difference between right and wrong, appreciate that for the act she was committing, or a compulsion she couldn't control. And if not, then that's it. She's going to go to prison. And if she did have a situation like that, was it brought on by her voluntary drug use? And if it was, then she's still going to prison. And the issue she has is it's up to her to prove it. It's not up to the state. The state had to prove everything in the phase 1 beyond a reasonable doubt. And now in phase 2, the burden shifts to her for this defense she's raising to show by the greater weighted evidence, credible evidence or whatever, that they should buy her story that she was insane at the time of the crime. And I guess their evidence was her dad talking, who seemed to blame it on the drugs, which doesn't help her case if the jury understands the law correctly. And the one expert they had who said that, yeah, I know she was on drugs, but I still think she was legally insane at the time. But it's not what they say. They say mental defect and all that. So the state had a couple of experts that was appointed by the court, or who were appointed by the court. The first was a competency expert. And so he said, look, I didn't develop an opinion on NGI. And then, of course, the expert who just testified, who did, and I thought I'd walk through that fairly methodically. So this is the last chance for a defense attorney to really score any points. But when it's your burden to prove the case, cross-exam is a hard place to prove your own case, right? You should have witnesses who prove that. So if you're not sitting here thinking that she was legally insane at the time she committed the crime based on the witnesses the defense called, it's hard to believe you're going to think that based on the cross-examination of the state's witness who has the opinion that she was not, she does not meet the requirements for the legal insanity defense. So that's it. Could she be a danger to inmates is a question here. I think she's a danger to herself and others, which meets the commitment to an institution criteria. I think she's a danger to everything for whatever reason. Her acts at issue in this case, perhaps magnified by the drug use, but does she have further capacity for violence? It seems like perhaps that she does. See a comment here. The jury will say she's mentally disturbed, not mentally defective, and she's going to prison. In my opinion, I believe that's the likely result too. Of course, you have the jurors because they're the ones who vote, and they are the opinions that matter. But we get to guess, and my guess would be concurrent, and congruent with yours. I agree with that. And they only need 10 out of 12 of the jurors to get to one direction or the other. Now, I did read a little bit. I'm not an expert on this, but as I was scanning the law on it, that what if you get a hung jury in phase 2? Even though you only need 10 of 12 jurors to come up with a verdict, what if you get a hung jury? Then I think you would retry just to phase 2 and not to phase 1. I believe that's the state of the law. So she's up the creek right now. So, Nan, I see your comment on what happens if she's recovered. Probably conditional release. That's a long shot. I don't, that wouldn't happen anytime soon. But I did go over a lot of that at the very beginning of the stream. Sorry to pun it, but they're about to talk again. But she can petition for conditional release if she thinks she's not a danger to herself or others. The burden's on the state to show that she still is. If not, then she should be released under conditions. But when you do something like she's done, that's a lot of water to carry, in my opinion. But it's not impossible. That's why you want to be found not guilty by reason of insanity, because then you're not a criminal, you're a client, and you could potentially get out. So, no problem coming in late. I just cranked it up early a little bit anyway because I found this stuff and figured I'd read it. That was before they actually started the proceedings. So no issue there. Yeah, somebody says I feel it would be unanimous, and I think that's likely too. Yeah. It's just interesting that they don't have to be at this phase.
Before we bring the jury out, just briefly, I've had distributed to you a set of instructions and a proposed instructions and a proposed set of outline as to how they should be given. There's certainly other instructions that could be given, that were given to the jury the first time, regarding objections of counsel, improper questions, things of that nature. Although they've gotten all those instructions already, I'm not sure the need to do that. But I'm going to start with the state. Mr. Saunders, do you have any feedback regarding the proposed instructions I laid out? Alternative suggestions?
No, and I have no additions. I'm fine with the ones the court selected. I guess our one quibble, our preference would be to do the instructions then closing, but that's the only change the state would have.
Mr. Freilich?
Your Honor, I agree with that. I'd ask that the court give the jury the instructions and then we could do the closings. When I look at 605B on question 1, it talks about at the time the crime was committed, did the defendant have a mental disease or defect? But then in question 2, it uses the word mental disease or defect as well. I'm wondering if the court would consider mental disease or mental defect, because it's either a mental disease or a mental defect.
Sure. I'd certainly consider that. The other thing is, you'll note, and I'll consider the issue that you've mentioned regarding when I give the instructions, and I want to just a brief conversation about that, but we can take that up when evidence is concluded. I gave you 605B. It was actually 605B, the version with the comments, because of the paragraph on the second page of 605B, the comment about the possibility of using the phrasing mental disease and defect, and then it's cited the case. I don't think that's appropriate to use "and" in this case, given how the evidence comes in. That case that cites phrasing it mental disease and defect apparently was in a situation wherein the assertion was that there was a combination that went into the events. A mental disease and defect were co-occurring, and so counsel asked that the word be changed. I don't think that's what's going on in this case. The evidence seems to come in this case that either there is a mental disease or a mental defect, and there's one or the other, and the jury can look at it and decide. They can choose either one, but it's not a case where we're driving at a specific argument that there's a combination of the two and therefore changing the word to "and." Nonetheless, wanted to call it to your attention. I don't have any problem with your request, Mr. Freilich, to change that question 2 to as a result of the mental disease or mental defect. Any problem with that, Mr. Saunders?
No.
Any concern with leaving it as an or, Mr. Freilich, versus an and?
I've always thought that it was an or, Your Honor.
And that's the pattern instruction. I only provided that one case note to indicate that there is a situation in which it was changed to and that's permissible. I don't think it's appropriate for how the evidence is coming in this case, but I'm going to leave it as or. You're not asking for anything else. You don't have any objection to or, do you, Mr. Saunders?
No.
Okay. Very good. I'll add that one word in, and then we'll discuss the order of the instructions versus your closings at the conclusion of the evidence, and we'll actually have an official instruction conference at that time. Okay, then anything else before the jury comes in? Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right.
Guess this was the unofficial jury instruction conference. Sorry for that. We'll do the official one
Doctor, you
later.
want to step forward?
Yeah, I think this judge has been great, but I'm also going to credit the attorneys here for being very professional on both sides. I mean, you may think sometimes the line of questioning is tedious or what are they really getting at, but also think about this murder trial with an additional situation of a phase 2 of insanity is almost over in a week. And how many trials have you seen just drag on forever or the lawyers do stupid things? So credit to everybody so far, in my opinion.
All right. Then we're back on the record, and we're up for cross-examination. Mr. Freilich, do you have cross-examination?
Yes, I do, Your Honor. Thank you very much. Dr. Engine, good afternoon.
Hello.
Hi. So you work for behavioral consultants, is that correct?
Yes.
That's in Milwaukee?
Yes.
Is that part of the Wisconsin Forensic Unit?
Wisconsin Forensic Unit is a division of behavioral consultants.
Okay. And with regards to this case, you did not do a competency evaluation, you did an NGI evaluation?
Correct.
You met with Taylor Schabusiness, correct?
Yes,
You recognize her here?
I do.
And ma'am, you met with her at the Brown County Jail on October 12th and October 21st of 2022?
Yes.
Have you met with her since?
No.
So it's been, is it fair to say that it's been about 9 months since you've seen her, correct?
Yes.
The first time that you tried to see her, there was some sort of a security issue going on and you were not allowed to see her, is that correct?
I was allowed to see her, but only cell side, and I thought that would be inappropriate to conduct an interview cell side.
As far as the things that you did to, put your report together, you relied on the 2 clinical contacts on October 12th and October 21st of 2022, correct?
Yes.
You administered the MMPI, the Minnesota Multiphasic Personality Inventory 3, correct?
Yes.
I see that number changes oftentimes. Has it changed?
It actually, I can't recall how long it was the MMPI-2, but it was that edition for several decades. And the MMPI-3 was based on 2017 population estimate. So it's a relatively recent addition.
And it gets updated and upgraded every few years, is that fair?
No, it was many decades before it was updated.
Okay. And it's essentially a true-false test?
That's the response format. It's more complicated than that.
Okay. What kind of questions are on this MMPI?
So I provided, an example that I made up, but there's various statements, and the respondent is asked to, respond true or false if they agree or mostly agree with the statement, or disagree or mostly disagree with the statement.
Strongly disagree?
I can't recall the test instructions, but something to that effect.
Do people that have, education issues or lack of education, do they struggle with the MMPI?
There is a reading level that's required to administer the MMPI. I don't recall it off the top of my head.
How many questions are on the MMPI?
About 335.
Okay. How long does it take to get through the test?
In the case of Ms. Schabusiness, I believe it was completed within about 90 minutes, maybe an hour and 45 minutes.
Sometimes longer if you have difficulty reading?
Could be.
So that was done. You reviewed some police reports in this case?
Yes,
A criminal complaint and some video footage, is that fair?
yes,
Photographs?
yes.
How did you get that information?
It was provided as part of the entire file. That's standard. It comes along when we receive a referral for an NGI evaluation.
Was it sent to you by the district attorney's office?
My office would have taken care of that. I received it from my office.
Okay. And then you looked up some information on CCAP, the Circuit Court Access Program?
Yes,
Basically a search on the internet of her background,
correct.
specifically her prior record.
Yes,
And then you looked at some Brown County Human Services records.
yes,
Would that be the Nicolay Psychiatric Center records?
yes,
So you looked at those?
yes.
And then you looked at some jail records?
I did not, I requested the jail records, but they had not been received.
And was there a request to see some Purveya Health records?
Yes,
Did you get to see those?
no,
Did you review any Bellin Health records?
no,
Was it your understanding that Taylor Schabusiness had some treatment stays at Bellin Health in the past?
yes, I understood that she attempted suicide at age 14, resulting in the admission to Bellin.
And what about at Purveya? Was it your understanding that she had gone there for some mental health treatment as well?
Yes, outpatient treatment,
Okay. So you were missing the Bellin records and the Purveya records, correct?
correct.
Now, you got some relevant history, some background information about my client, correct?
Yes,
You found out that she was born in Chicago, correct?
Yes.
She was raised in Lindenhurst, Illinois, is that fair?
yes,
And then she moved to Green Bay in 2009 at maybe age 11?
yes,
And that same year her mother passed away?
yes.
Was it your understanding that her mother died in the house when she was there?
I don't know those details.
Was it your understanding then that she was raised by her father, Arturo Coronado?
Yes,
And then did she also relate to you that she moved to Cotulla, Texas when she was 16 to live with her grandparents?
yes,
And that she had a series of moves. She lived in Cotulla and Alice, Texas, and Jackson, Mississippi,
yes,
and then came back to Green Bay?
yes,
That's kind of the progression, is that fair?
correct.
You found out that she was also married in February of 2020?
Yes,
And when you were involved, had she given birth to her child?
yes, that was October 2021.
Ultimately, the child went to live with the grandparents, correct?
Yes,
In Texas?
yes,
Did you garner information that she was in an abusive marriage with her husband?
What I gathered was that she was married. There was discord within the marital relationship, which led Ms. Schabusiness to rekindle her friendship and romance with the victim in this case, and that would have been in 2020. I can't speculate beyond that, the
Did you-
nature of the relationship.
Did you get any information that her husband was hitting her in the head?
Objection
No.
asked and answered. She doesn't know.
No, that's a different question.
Yeah, go ahead. Overruled.
No.
Okay. So you got some background regarding her life, correct?
Yes.
Did you find out that she went to middle school in Green Bay and went to Bayport High School as well?
I don't recall that specific detail. I know that she graduated high school in Texas.
As part of the educational, assessment, as part of your report, did she report a history of some learning disabilities or difficulties?
She did. She attributed them to a diagnosis of attention deficit hyperactivity disorder.
And was it such that she had some issues with school, suspensions, ultimate expulsion?
Yes, she was expelled, the result of fighting.
The information that you have, as far as your November 14th, 2022 report, it's somewhat stale. Is that fair?
I would disagree with that.
It is from last year, though, correct?
Correct.
Nobody gave you any reports from Bellin Health to review, correct?
Correct.
You could have, doctor, upgraded your report by looking at additional records, Bellin Health, and the Purveyor records. Is that fair?
Where I left my report, as indicated on the last page, is that I would be happy to receive any additional records that I was unable to obtain, and I would update my report once received if it changed my opinion. I received no additional records after submission of this report.
Your colleague in the field is Dr. Matthew Seipel, correct?
Yes.
And did you confer with him with regards to, your opinions, your assessment, your evaluation?
No.
Did you share any information with him?
I did provide him a copy of my records that I obtained from Brown County at his request, and that's a common practice among evaluators.
Sure. But fair to say that he did not he didn't reciprocate by sending you the Bellin Health records that he had?
No, he did not.
Okay. That is something that could have been done, correct?
If I was not alerted that those were part of our practice, I wouldn't have known to request those. And it's not clear to me that Dr. Seipel would know that I was looking for those. Typically, what will happen is that I will receive additional records from one of the court principals with an indication that they would like a second review of the issue.
Does it surprise you that, as far as Dr. Seipel is concerned, I provided the Bellin Health records to him for his evaluation and that he didn't send them to you?
Can you repeat the question, please?
Does it surprise you that, I sent the Bellin Health records to Dr. Seipel and he didn't send them to you?
That would not surprise me because unless he had instruction to provide them to me, that would not be common practice.
Okay. You don't share information then, correct?
Only upon request, if it's appropriate, if it would be appropriate and permissible and specifically requested, but we don't, as a general practice, pass records between doctors.
Okay. If you had received these records, you could have done a supplemental report. Is that fair?
If it changed my opinion, if I felt that it was relevant and added meaningfully to this evaluation, I would have, yes.
Now, as it relates to the Nicolay Psychiatric Center, you had a chance to look at all those records, correct?
Yes,
And was it your understanding that Taylor Schabusiness was committed and she was sent to that facility for, mental health treatment, correct?
yes,
And you were aware, tell me if you were you aware of an order for civil commitment for her?
I was not.
Had you ever been made aware that she was under an order to take psychotropic medications?
No,
If I told you that she was civilly committed in April of 2021, where the court, a court of law, determined that she was mentally ill, would that cause you to have any concerns?
it would certainly be relevant, but it does fit with the information I already had, that Ms. Schabusiness was discharged from that facility to outpatient treatment with the goal of receiving substance use treatment.
And did you know when she was at the Nicolay Psychiatric Center that she was under an order to take medication?
No,
Did you know that she was required to take antipsychotic medication?
yes, I was aware that she was prescribed Abilify, an antipsychotic.
Injectable antipsychotic?
Initially oral, later injectable.
Now, during your two contacts with her in October of 2022, did you get a sense that she was suffering from any kind of auditory or other hallucinations?
She reported that to me, but her behavioral presentation to me was inconsistent with her self-report. And the quality of her self-report was not consistent with genuine psychosis.
Did you gain any information that she was suffering from a mood disorder when you met with her?
Her emotional expression was odd when I met with her, but I would, she did not present as acutely depressed or hypomanic, let alone manic. So I wasn't seeing significant indication of a major mood disorder.
You did see in the Nicolay records that there was a diagnosis for her of bipolar 1, correct?
Yes.
With psychotic features, is that correct?
I don't recall that qualifier, but certainly the record does indicate that she was experiencing psychotic symptoms at that time.
And that is a qualifiable mental disease or mental defect, correct?
Yes.
Do you agree that if someone has an underlying mental health disorder, that using or abusing drugs can exacerbate that mental health disease or defect or condition?
I would agree with that statement.
Did you notice that Ms. Schabusiness was a poor historian when you asked her questions and asked her to expound on whatever topics of discussion?
Where I found that she provided a sufficiently detailed history. Where she was lacking was when I asked her to describe her recollection of the underlying offenses.
Did you note her to have memory loss or memory impairment?
I did not, aside from that self-reported amnesia, I did not detect memory loss.
how much time did you spend with her on October 12th of 2022? Do you know?
I would estimate about 15 minutes.
15?
Yes.
Okay. And then, doctor, on October 21st, 2022, how much time did you spend with her then?
I can't recall. My best estimate would be about 3 hours, but again, that's 9 months old.
Long time ago, right?
9 months, yes.
Okay. Do you agree that methamphetamine use does cause brain damage?
It does have that potential.
And how about adolescent long-term marijuana use? Same thing?
I'm less certain about that.
Okay. Certainly, if you're using heroin or cocaine or drugs like that, that can cause brain damage as well.
Yes.
When you met with her, you did find that she exhibited some psychotic symptoms. Is that fair?
No.
In some of the records that you reviewed through Nicolay, did you recall reading anything about a recommendation for her to be on Haldol?
No. And then to be clear with your last question, I did not personally observe psychotic symptoms during the moments of my evaluation of Ms. Schabusiness, but I did see in the record indication of past psychotic symptoms, to be clear.
Okay, yeah, thank you. Did you see in the records there was a recommendation for her to be on Haldol?
No, I don't recall that.
You were asked to opine on the NGI issue, correct?
Yes.
Dr. Seipel was asked to opine on the competency issue, correct?
That is correct.
We're not talking about competency, we're talking about NGI. Is that fair?
Yes.
You had a chance to review Dr. Layton's report, is that fair?
Yes.
You read through the entire report and you're familiar with Dr. Layton's opinions, correct?
Yes.
And do you agree with her findings?
No.
You would agree that Dr. Layton's report is more current than yours, is that fair?
Well, it was authored more recently, but the authoring of the report has little to do with its relevancy because we were both doing an evaluation that was retrospective. So if you're looking at it, my evaluation would be more current than Dr. Layton's because mine was in closer proximity to the alleged offenses. So that's another way to look at it.
But another way to look at it is your, with due respect, your report is lacking because you don't have you haven't reviewed the Bellin Health records, correct?
It is missing that piece of information, but I would like to point out that it's not common for me as an evaluator when I'm looking at an offense that occurred in 2022 to be requesting records from when one was a teenager. Those would not be, they're certainly generally relevant, but they say little about what was going on in 2022.
Did Taylor Schabusiness tell you that she had no memory of the alleged offense?
She
tell
did.
you? When did she tell you that on both dates? October 12th and October 21st?
I did not ask her about the offenses on the first date. I only asked her on the second date, which is when she reported the amnesia.
That was on October 21st of 2022.
Yes.
And in reviewing those Nicolay records, it's true that she was hospitalized, correct?
Yes.
For about a month, right?
A
A couple weeks?
Somewhere between a couple of weeks and a month.
Okay. And that she was prescribed some medication for nightmares?
I believe that she was prescribed Abilify.
And Go ahead.
refresh my recollection.
Page 3.
Thank you. Okay, sure. She did say Prazosin for nightmares.
Okay. And it was such that when you talked with Taylor Schabusiness that she was actively hearing voices, those were the comments that she made to you?
Yes,
Did she indicate to you that she was hearing voices, in her cell?
yes.
Who were they of?
I think she was less clear. They were very vague. She may have suggested that she was hearing voices of her coworkers, pejorative in nature. She also said that she was hearing a voice saying, "I love you." I don't know who she said was saying, "I love you."
Can you help me with this? What is a manic symptom?
That would be extreme mood elevation, increased goal-directed activity, decreased need for sleep, decreased risk appraisal. Those are some primary characteristics.
Extreme mood, like throwing a chair at a doctor?
What I gather that you're referring to is the evaluation of Dr. Lighton of
Yes.
Ms. Schabusiness. I'm hesitant to characterize that as a product of a manic episode.
As far as you understand, it happened out of the blue, correct?
Yes.
Did you have the occasion to review the report from Dr. Tracy Lucetta?
No.
This is a yes or no. You could have gone back to see Ms. Schabusiness after October 21st of 2022. Is that correct?
If you're looking for a yes or no answer, I'm not able to answer that in a yes or no fashion.
The fact is you didn't, correct?
That is correct.
Did you see, when you met with her in October, did you see her use odd or unusual facial expressions?
Yes, I believe there were instances of her smiling inappropriately.
It didn't track or it didn't follow, correct? It was out of context, is that fair?
Yes.
Okay, I have nothing further. Thank you.
Redirect, Mr. Saunders.
Doctor, I want to pick up on questions towards the end there. You were asked to describe what a manic episode or manic symptoms are. Is that right?
Yes.
With respect to a bipolar 1 diagnosis, one of the requirements is a manic episode, right?
Yes.
And how long do those typically last?
They can last for quite a long time. And then that would be, based on my experience, that they can last as long as months. Oftentimes until treatment is administered.
The diagnostic criteria sort of requires there to be a week of manic episode. Is that fair?
I would need to look at the DSM, but that would make sense.
All right. So you said that you were hesitant to say the instance of chair throwing was a manic episode. Is that what you said?
Yes.
And can you explain why?
There are many reasons for a person to throw a chair. One of them could be due to a manic episode. But before I would make that conclusion, I would want to have compelling evidence that such a diagnosis is appropriate. And that would need to include objective evidence, meaning observation over time when a person is not being, thinking that they're being viewed, things of that nature.
So I guess then, would some of that objective evidence be to consider time periods both before and subsequent to the manic episode that you're observing?
Yes.
Why would that be helpful to know?
It would speak to consistency of behavior. There's a lot of information that can be gathered by looking at behavior over time. When is the onset? Does it happen? I mentioned this earlier. Does it happen when people are not being, when they do not know that they're being observed? Things like that. And then there's more, the more objective evidence there is, the more credible that diagnosis can be.
So I guess in general, if you're attempting to determine whether somebody is actively having a legitimate manic episode, you sort of look at the time frame both before and after.
Yes.
You were asked some questions about your interactions with Ms. Schabusiness, about her reporting or endorsing that she was hearing voices. Do you remember those questions?
Yes.
And you indicated sort of her response to those were sort of vague in terms of what she was experiencing.
Correct.
In your opinion, did that appear to be consistent with genuine psychosis?
No.
Why is that?
To me, my take on them was that they were represented some social anxiety, some rumination, her thinking about her circumstances. They seemed like more of an internal dialogue versus an actual auditory hallucination, which can tend to be more bizarre. You also will see behavioral indication that a person is responding to internal stimuli or the auditory hallucination. So you'll see indication, maybe the person won't even say that they are experiencing these voices, but they'll be distracted, have a difficult time completing their thoughts. It's a lot more subtle of an expression than simply saying, I'm hearing voices.
And none of the sort of other things you are trained to look for you observed in Mission Business?
Correct.
And in addition, you've already testified to concerns about exaggerating of symptoms.
Yes.
You were asked questions about review of certain records, particularly the Bell and Health records. You were aware that there was a prior attempt of self-harm previous in Mr. Business's history?
Yes, at age 14.
Okay. And records from that age, 10 years or so from prior to the date of the offense that you're attempting to determine here, do you believe anything in those records would substantially change the opinions you're testifying here to today?
As I know it, there's not anything that would speak specifically to the issue of the NGI plea. But as I indicated, I would have been happy to receive those records if they had been made available to me. I felt, though, that for me, one of the main issues was Ms. Schabusiness's use of methamphetamine at the time of these offenses, and I don't think that information generated 10 years prior would change that. So in sum, no, I do not believe those records would change my opinion.
Okay. And then I'll sort of pick up on the methamphetamine you brought up because you were asked some questions about that, about psychotic symptoms that you had observed in Ms. Schabusiness's records in the past. Is that fair?
Yes.
And are you aware of any of those symptoms that were reported absent the context of methamphetamine use?
No, I am not.
And So like concepts like, psychosis or meth-induced psychosis, I think you mentioned, those are as a result of methamphetamine use.
Yes, my review of the record indicates that all of the psychosis observed objectively occurred in the context of methamphetamine use.
Then finally, you were asked some questions about the MMPI. I think there was a question about like lack of education and if that can impact that. Is that, you remember that question?
Yes.
All right. Is there any information you're aware of any cognitive deficit for the defendant?
No, my understanding was that she attributed her learning difficulties to ADHD. She did not have an individual education program or IEP that would signify learning deficits, and she has a high school diploma, which indicates she had sufficient reading level to take the MMPI 3.
Thank you, doctor. Nothing further.
Anything on those topics, Mr. Freilich?
Did she say that she had concentration issues?
I don't recall that.
When you talked to her, she was very quiet, correct?
She was soft-spoken.
Didn't give a lot of information, correct?
I disagree with that. I obtained a reasonable history from her.
Okay. It wasn't like she gave one-word answers,
No,
but the responses were short. Is that fair?
no.
Okay. Nothing further.
Anything on that?
No.
Thank you, Doctor. You can step down.
Well, this might be it.
Any other witnesses from the state?
No, Your Honor, the state rests.
Any rebuttal testimony, Mr. Freilich?
No.
Okay. Ladies and gentlemen of the jury, the evidentiary portion of this case is now closed. So to give you a sense of what's next, it's similar to the process that you've already experienced, and that is I'm going to instruct you as to the rules of the law that you need to apply. The attorneys will make their closing arguments, and then you'll deliberate. I need a few minutes to work with the attorneys. The instructions are much shorter this time, so I won't need as much time to work with them on it. But I do need a few minutes to finish those up, so I'm going to excuse you at this time. All rise for the jury.
This judge is not joking. They are moving this case. The eagle is flying.
Be seated.
We'll have our jury conference. Official jury instruction conference, perhaps.
Counsel, I want to address some of the issues that you raised before when we were talking about the instruction. I don't have a problem delivering the instructions before you do closing arguments, and so I would probably take 160 and move it. And I want to just
I don't
indicate
think
the
so.
reason that I had proposed that is
Just my
for this
opinion.
reason. When I look at 605, the last two paragraphs in 605 seem very similar to 515, which is read after the closing arguments, before the jury goes out. And so I was looking for something as a way to kind of conclude the matter, as opposed to the last argument is made and I just say, go. So my suggestion is, if I read the instructions in the order that you've proposed, other than moving 160 to after 605, other than that, I'm proposing that I give a modified 460 just before the jurors leave. So after closings, I give a modified 460. 460 is the instruction, and I'm having my judicial assistant draft that up. That's the one that says something as follows, and I know you gentlemen have heard it before. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. It's that instruction. And the only thing I would eliminate is the second paragraph of that instruction, which says, You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. I delete that paragraph because, first of all, this isn't a question of guilt or innocence at this phase, and secondly, because they're actually informed about the consequences of their action when I read 605. So I think that paragraph should come out, but in exchange for giving the instructions before you close, my suggestion is give that modified 460 after your closings. I then swear the bailiffs and send the jury out. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. I gave you the proposed verdict forms, and what I noticed as I was looking at them, there's spots for the dissenting jurors to sign, but there was no spot for the foreperson. My judicial assistant is making that change. So what I'm going to do is I'm going to go make these revisions and then bring them back to you. But there are a couple of other things I need to call to your attention. First of all, a change that I made in 100, the opening instruction, is in the third paragraph. You should have that. I put it in bold. That if any member of the jury has an impression of my opinion as to the issues in this phase, disregard that impression. That would take the place of the language that's given in the first phase, which is, if any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty. So I switched that. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then Mr. Freilich, I need to speak with you, and perhaps you need to speak with your client about whether you want me to give 315. That's the instruction that your client, during the first phase, elected that I give. That's the instruction that says a defendant in a criminal case has the absolute constitutional right not to testify. And that's really, she has an option to have me give that or not give it.
Talk to my client. We both agree that you could read 315.
You're asking that I give that.
Yes, I am.
Mr. Business, you've had an opportunity to speak with your attorney about that decision?
Yeah.
Okay, and I know you spoke with him about it at the beginning of the first phase. You'd like me to give that instruction in this phase?
Yes.
All right. I'll give 315. 640, mental disease or defect expert opinion testimony. The interesting piece there is that the last paragraph, the court has appointed, and then it says to fill in the name. Two of the people that were appointed by this court testified. Only one on the NGI piece, but two of them testified, and they both testified they were court appointed. And it indicates that you shouldn't give the weight, give their testimony any greater weight. I think probably both of their names should be in there, but I could see an argument that only Dr. Engen's name should be on there because she was appointed on the NGI. On the other hand, they were both appointed by the court, and the notion that they shouldn't be given any greater weight than anybody else seems to apply to both of them. Mr. Saunders, any opinion on that?
Not really. I guess the preference would be to include both.
Mr. Freilich?
It would be my position that we would only use Dr. Christina Engen because she's the one that did the NGI evaluation.
Okay. I'll just give Dr. Engen's, would keep pronouncing her name differently. I've heard it pronounced both ways. Is it Engen, like an engine, or is it Engen? I thought I heard her say Engen.
It's the latter.
Engen, I think.
That's how I'm going to pronounce it. Moving on then to 605, there are some options that we need to address. And that is under the subheading meaning of mental disease or defect. I have some thoughts about which ones seem appropriate given the evidence, but let's just run through them. The first option is, because it indicates that in that particular portion, add the following if supported by the evidence. First, temporary passion or frenzy prompted by revenge, hatred, jealousy, envy. That just doesn't seem to apply. I don't think it should be inserted. Agree with that, Mr. Saunders?
Yes.
Mr. Freilich?
Yes, I do.
That'll be out. The next one, an abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. Mr. Saunders?
I think that should be included. Particularly well, there was testimony about the criminal conduct, but antisocial, I think that kind of fits into a lot of the jail conduct reports, other behavioral things that the defense has raised.
Mr. Freilich?
I disagree. I didn't hear any doctor or professional say anything about antisocial conduct. So I would object to that.
I'm going to give that instruction for this reason. There was a lot of testimony about conduct that the average person could characterize as antisocial. And I think that's an important piece of information for them to have. So I'm going to keep that in. I note Mr. Freilich's objection, but that's going to be the order of the court. The next one, voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. I note that the parties stipulated at the last phase that should come in. I'm assuming that's where we're at now, but Mr. Saunders, you're asking for that?
Yes.
Mr. Freilich?
I'll agree.
Okay. The next one is a temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Mr. Saunders, you're asking for that?
Yes.
Any objection, Mr. Freilich?
Yes, I would argue that it's duplicitous. It's doubling up. The paragraph before I think, says enough. It's mentioning it twice, basically.
This is diabolical.
So,
Well, I think the difference is voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. The other one is a temporary mental state. The other one referenced temporary mental state versus voluntary intoxication. Temporary mental state, which is brought into existence by the voluntary taking. And I think that's consistent with some of the testimony that has been offered here. So I understand the argument, Mr. Freilich. I'm going to include that option. I think it's appropriate in light of the evidence that's come into this case.
Your Honor?
Yes.
One more argument, and I respect the court's ruling, but just to make sure I'm doing my part, is that just saying it a different way? I would make that argument too.
Well, a voluntarily induced state of intoxication by drugs or alcohol does not constitute a mental disease or defect.
Temporary mental state. This judge is not looking
I was
to
just saying it a different
make
way,
it
in my
too
opinion,
easy.
my humble opinion.
in the judge's humble opinion. I'm going to leave it in there, but good argument by the defense. He does need to do his job.
Mr. Saunders, any response to that?
yes, I think they're pretty clearly different. A voluntary induced state of intoxication refers to using methamphetamine, using alcohol, using some other illicit substance. A temporary mental state brought into existence, I think, refers to the circumstances that Dr. Engen testified to about meth-induced psychosis or symptoms that are brought about by use of substances, because that speaks to the mental state. Induced is basically the same thing as which is brought into existence. So I think they're different.
Okay, I think the difference, Mr. Freilich, in response to your objection is for someone to be in a voluntary induced state of intoxication, the jury couldn't find that that's a mental disease or defect. The next option is if a mental state exists, if there's a potentially a diagnosable mental state that exists on a temporary basis, so not just the intoxication, the mental state, which was brought into existence by the use of drugs, that does not constitute a mental disease or defect. I think they're different, so I note your objections and your amendment to your objections, but I'm going to give both of those because I think they're different.
Thank you, Your Honor.
The next then is chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Mr. Saunders?
I don't think this one should be given. We didn't hear testimony about the latter part of that there is some permanent, and we talked about this with Dr. O'Donnell, that there is some permanent condition that the defendant has. So I don't think it's an appropriate instruction to include.
Mr. Freilich?
I strongly disagree with the state on this. I think this language should come in. The court should consider it. I asked, I believe, Dr. Engine and Dr. Seipel, and I believe Dr. Layton, that, using drugs over time can cause brain damage. And so I'd ask that you allow that as part of the jury instruction, Your Honor.
Anything else?
Well, yes, it can, but there's been no evidence that if the condition has become permanent, that is something the defendant's afflicted by. So I don't think it's proper to instruct the jury on something that can be out there if there's no evidence that this actually is in existence. I think it invites speculation. I think it kind of is confusing to some extent as well. If counsel wanted to have an expert to testify about a permanent condition the defendant has, they could have done that.
Your Honor?
Yes.
It's crystal clear to me that this should absolutely come in. This young lady, Taylor Denise Schabusiness, was under a court order for involuntary medication and an order for civil commitment, which it doesn't happen very often. She was found by a court of law, by Judge Lee Joyce, to be mentally ill. And she was at the Nicolay Psychiatric Center for approximately a few weeks, where she was receiving injectable Abilify antipsychotic. She was getting treatment, and it was clear, the records replete with the fact that
But involuntary
she had a chronic
intoxication is a separate
problem
defense
with
in Wisconsin.
meth,
It's interesting.
methamphetamine, marijuana.
It's a different
So I think it's
procedure.
totally on point, and it should be something that the court should consider. The operative word, in my humble opinion, is can. That word can. I think that makes it such that it would be applicable in this particular case.
Yeah,
I think the
guess we're going
focus
towards
is
brain damage,
if the
not a
condition has
temporary
become
mental state.
permanent.
Yeah.
And
Yeah.
whether that's supported by the evidence. There's no doubt that chronic use of drugs or alcohol has come into this case.
Yeah, if you had a temporary mental state due to involuntary intoxication, that's a separate defense in Wisconsin. Actually, it's
Satisfied
tried
in
in
light of the
phase
state
one.
of the record.
Wouldn't be a phase two.
That it ultimately comes down to what the jurors heard. There has been a great deal of testimony regarding the use of drugs or alcohol.
Yeah.
There were some questions placed to the defense expert about impacts on a person long-term using various drugs. I'm satisfied the jury can assess that. I'm going to give that instruction. Certainly, the parties can argue that they don't believe the evidence supports that particular aspect, but I'm going to give that piece. So I'm going to include that.
Very interesting.
And then that's the last option that has to be selected. I'm going to make these revisions then, and then I will give you a final copy of them, and then we will move, we'll bring the jury back in, and we'll move to instructions and closings. All right, we are in recess.
Thank you.
That's all. So if you have involuntary intoxication producing, I guess, a temporary mental state, and that's your defense in Wisconsin, that's actually a separate defense, and that comes into the main trial. It's not a bifurcated trial like this. And if you have voluntary intoxication, as you've heard the judge say, that is not a predicate, or you can't put an insanity defense in based on that. So I guess the idea, though, is if you just did drugs forever, you damage your brain, and so it's not a temporary mental state based on voluntary intoxication at that point or something like that. But whatever. We'll see. I want to hear him actually read the instructions and then It'd be good. I gave the tip earlier in the stream about finding a judge's handbook if you can in state courts if you're interested in the law, because they become very practical with examples of how the judge should proceed. Another thing you can do if you want to learn what the law is in an area quickly is find their pattern jury instructions, like what the judge went over here, because there you see the justice system trying to take its complicated concepts and funnel them down into something that you can tell the jury, hey, here's the rule applicable in this kind of case, in a way they can understand. That's the whole point of a jury instruction, is not to be a 15-page long court decision about the nuance of the law. So jury instructions can be very useful to get a general sense of the law, but it doesn't tell you everything. And you have to look at the constitutions, the statutes, the case law. It's a lot, but it's a quick way to get a sense of what's going on. So let's see what we've got here. So I guess we'll just give these guys a few minutes, and I think they're bringing everybody back. Yeah, I was thinking about something else too while he was talking about that. I'm going to admit I didn't catch everything they said on this. Your brain's been damaged instruction, so I want to hear that one, since I guess the judge is going to let it in. That's the most pro Schabusiness thing I've heard out of this. Now, having said all that, I think consistent with what the experts have said today is, irrespective of her long-term use of substances or drugs or whatever, is the fact that she wasn't going out and cutting people's heads off on the regular. She had this one gigantic episode, and she was on meth at that time. If she's not normally doing it, it's hard to think that meth didn't play a role in that, and that it's voluntary intoxication at that time, and it shouldn't support an insanity defense. So to me, whether she knew what she was doing was right or wrong, I can't see her winning on that. Did she have a compulsion that she couldn't avoid that wasn't induced by the drugs? It's her burden to prove it. So I guess we'll see. They're not deliberating now. That's the question right now. The judge has called them into recess. They finished the jury instruction conference. So the jury has two more things to endure before they consider a verdict, and that is the jury instructions and the closing arguments. And then they'll get the case and go back and deliberate and reach a decision. You may have heard him say about the juror form that he has spaces for dissenting jurors, because like I mentioned, they don't have to have a unanimous verdict in this phase, and the burden is on the defendant in this phase. So the judge has got to make some changes and maybe engage that big league printer that they swear everybody in that courtroom, and print off the final jury instructions and give a copy to the parties, probably in addition to sending them electronically to make sure everybody's getting everything in all ways that they can. And then he'll read those out to the jury. Also, there'll be closing arguments, and then that'll be that. So I suppose that, they're going to make the argument that all the things that happened to her when she was a kid and her chronic drug use, that she had this mental condition and didn't perceive right or wrong and all that on a regular basis, and that her meth use was not the cause of that, because she's been on meth many times and she wasn't cutting somebody's head off. So it was her general deterioration mentally. Then she became insane, I guess is what they're going to kind of say. I don't know. Sometimes juries want to let people off for this, and that's what they can do if they want to. And sometimes they don't. Usually they do not. I thought, I guess, there's obviously a lot of testimony in this phase of the trial about her prior drug use and her weird behavior and things like that. But I felt like it was a little light on establishing her lack of ability to know right from wrong. That's what I thought. Now, granted, when I was listening to the defense's case, I was actually doing work this morning on other things, so maybe I missed some of the nuances of it. But I didn't hear that too much. I didn't hear that this particular mental defect meant that she didn't know right from wrong, and here's a good, solid explanation of why you should absolve her of responsibility for this crime, which is what you're asking the jury to do, is to vote for you to relieve you of criminal responsibility. So I don't know about, what her attorney may have done or tried to do about MRIs or CAT scans or whatever. And who knows if they did that stuff, whether it would have helped her case or not. I don't know. I mean, I'm not going to conclude, certainly, because I'm not a doctor, whether they could have done an exam that would have supported what they're trying to claim now. Sometimes it's better to not have firm evidence if it's going to go against you. So let's get some of this stuff, which I do know a little bit more about. Can it be found she's to be committed without chance of parole? Does this ever happen? And the answer is no. The commitment period is can be or should be the length of the potential criminal sentence that she would have had if the verdict had been sustained. But the judge then decides whether that commitment is in an institution or is released under conditions. Now, of course, in this case, the judge is going to decide institution, but the judge has to make that finding, which would be the natural thing to do here. Then, when the person is put in the institution over time, they can petition for conditional release because, in theory, they're being treated. They're not a criminal now, right? They're a client. I read that handbook at the beginning of the stream of how they deal with people like this in the system, the actual handbook they use, and they refer to the people then as clients. And then if she becomes not a danger to herself or others during one of her petitions for conditional release, and the state can't prove that she is dangerous to the burdens on them, then in theory it should be released with conditions. Now that's the state of the law. Is that easy to do or easy to do quickly? It's not going to be. I mean, they're not going to let her out right away or anytime soon, but it does happen. People who have committed horrible acts that would be criminal, except for the fact they were found not guilty by reason of insanity, are released after a long period of time, sometimes just on conditions. So that's, if you're the defense attorney, that's the thing you want to have happen here. You want her to be found not guilty by reason of insanity, especially if you believe that, because then she's going to get treatment. She's not a criminal if that happens. So if you can treat her and restore her sanity, and she's not a danger to herself or others, then in theory you let her come out of there and start experiencing life again, right? The treatment is not punitive at this point if she's insane, because she's not criminally responsible. But if you don't think she's insane, then you think she should be in prison. And if she goes to prison and she has mental issues, there's nothing to say that she can't be treated there for that. This is about whether she's going to be held responsible for the crimes that she committed or not. Yeah, I don't know why. I mean, I'm just going to doubt that happened at all. I mean, it doesn't, there's no general rule that you have to turn over inculpatory evidence. I mean, exculpatory evidence is different because you got the Brady rules and stuff like that from Supreme Court precedent. So that's different. But having said that, there is usually discovery requests that run on both sides, and it gets down into that. But I just don't think that happened. Let's see. Can the jury take that into consideration? And I apologize because I probably missed. Maybe you're talking about this comment above that. Could it be possible the defense? Yeah, I think actually we just talked about that. So I'm not sure Trish's comment what that's referring back to, because I was too busy blabbing and not reading. How do we know she's never done this before and may not have been caught? Well, we don't know, of course. I mean, it's unlikely she did this before. Unlikely, I say. Having said that, I don't know if she's ever been violent before in times when she wasn't caught. That's a good point, and I certainly don't know the answer to it. I will object to descriptions about crazy because she's a butcher and all of that. Yeah, I think that's a suitable thing to do. I mean, to me, I don't have a problem with somebody calling her crazy or what she did was crazy simply because it's so far outside the norm. But that's not to say, of course, that she meets this legal insanity criteria or anything else under actual mental health doctrine. It's just bananas to do that to somebody, and evil is another word for it. Something's wired up wrong in her. If the judge said, do you think something's wired up wrong in her? then I would return a verdict of, oh yeah, Judge, we need a bigger box for yes, because I got to make a big check mark. And that's not the same thing as saying you should be let out of prison or not go to prison and then sent to a mental health facility where you might get out later. Those are two different things. So what you're going to hear when the judge reads, I think it's jury instruction 605, but I might be wrong because, I don't really know their law very well, but I did look at it a little bit. Anyway, the jury is supposed to be told that if they find her insane, the judge will have her committed, although she might be, I think it's something about it, she's not dangerous to herself or other. I can't remember all the words that it said, but they're generally advised that if she's dangerous, she'll be institutionalized. And if the judge says she's not, then she might receive some other kind of treatment. I think they do know that. And then, if they find her insane, then the judge will have to do this hearing, it looks like to me, where he decides and puts the findings on the record of how her commitment should be handled, whether it should be in an institution or released on conditions. And he's gonna say institution, of course, because she's incredibly dangerous. I don't know. You could look at her and also listen to what she did and not think she might do something bad to somebody again at some point. I don't know that it was all meth. And at least according to some testimony I did hear, she's found her way to intoxicate herself with other things sometimes while she's in custody of one sort or the other. Wasn't she sniffing something or something like that? So, the question is, did they bring up her attack on her previous attorney? And I don't think that they did. And I see somebody else saying that they didn't. I didn't hear it, but I didn't hear every minute of this. I had to take a call, and plus I missed some of it this morning, but I was trying to listen to it. They did bring up her throwing a chair, though, at the psychologist. So that's interesting. And competing testimony. I didn't really have much heartburn with the experts in this case. Even the one who testified for the defense did not deny her drug use at or around the time of the crime, which is important because that's a fact. And so if you have some integrity in what you're doing, you should acknowledge that fact, and she did. And she also acknowledged the different findings of the other experts in the case. Yeah, there was testimony she was having inappropriate contact with male patients when she was in the hospital facility. I would not have a hard time believing that she is, that her wiring did not follow the wiring diagram that you should use for a normal person. So, whether she was born that way, raised that way, or made herself that way with drugs, or some combination of all of that, she's in bad shape mentally. And it would strike me as be tough for me to believe that she can be treated in a way that she isn't dangerous anymore, or could be relied upon to be not dangerous. So you just don't know. Like the case we had in Chapel Hill, where Wendell Williamson was being treated for the voices and things he was hearing, and said that was effective for him. But when his care was switched and he went off of the drugs, they came back. He knew he was supposed to stay on those, but he didn't follow that protocol, and they didn't follow up, I guess, enough with him, and he went off of it and ended up killing people. So if she's let out on conditions, what conditions could it be that you'd be sure that she's not going to fall back into her prior behavior, or that the drugs are necessary for her to be violent in some fashion? One of the things the defense experts did here was certainly lay a predicate that even when she's in confinement and can't access illegal drugs, she still does really weird things that indicate a fascination with violence and a potential for violence. So it's not good if you're going into treatment. I mean, that's part of the record now, right? So, let's see. Like I say, a long time ago when I did that, went to one of these places to deal with somebody who was not guilty by reason of insanity, the guards in that place looked like they could handle the situation, whatever the situation might occur. And so I definitely want to make sure they knew who I was and let me out when the time came, because when it's a mental facility, but you go through a lot of security procedures to get in there, a lot of locked doors and things. It's very secure, or it was back then. But sometimes people get out and can wander around and take off and stuff. So that also happened in the case I mentioned before. The guy decided just to leave the yard of the mental health facility here in Raleigh. It was Dorothea Dix at that time. And he wanted to go swimming. So he did, I think, down at Lake Wheeler, which is quite a walk from Dorothea Dix. But I think he said Lake Wheeler because that Dorothea Dix is this way and Lake Wheeler's that way. And it would be a substantial walk, but you could do it. And he did it. And then I think he ended up calling and saying, yeah, I'm over here. Come pick me up, because the police were looking for him at that point. So you don't know with these kind of things, but some of these people also can be released with conditions later, and they don't act out. And that does happen, and somewhat more quietly after the cases die down, of course, over a long period of time. So I would put my money, if I were putting money on something, that they will not find her insane and she'll go to prison. But it's their decision, and get mad at them either way that they decide. I think this phase of the trial to me is a little more confusing than the first phase, because it was so obvious that she did the crime. They had plenty of evidence, and then they had her on tape just confessing to it in great detail for over an hour. Hard to beat that if you're the defense. But this whole thing about understanding what the law means by insanity, because notice it's a not guilty by reason of insanity plea, but then when they tell you the definition of it, if you're on the jury, they're not using the word insane. They're using mental disease or defect. And it's not just whether you have that, but whether that impedes or stops your ability to understand the rightfulness and wrongfulness of your conduct, or this compulsion you can't control. But then if it's a result of the drugs, then it doesn't count. And also it's her burden to prove it. But now we're going to have an instruction about what if she had brain damage from long-term drug use. There's really no evidence to support that. It's just all hypothetical. So, the jury could have more to talk about here just from the complexity of it from a legal standpoint, if not the factual standpoint. This is more complicated, I think. So the judge talked about jury instructions with the attorneys, finished that, and now he's got to go back to his computer and open up Microsoft Word or whatever. Probably not using that, probably using some state program for changing documents, and that's very tough to do. And get that giant printer going. And here comes the judge.
Okay.
He's done it.
Be seated.
The judge can throw out
You should
the
have
jury's
now a
decision.
copy
He
of
can't
the,
convict somebody over the jury, though.
of the instructions that I propose to give to the jury, and again, I will give this before closing arguments. I'll start with the modified 100.
All right, let's hear what the case is. This is the case.
There's one missing. Well, in any event, there's the add-on at the end of 100, but I'll get to that in a minute. I'm going to give 315. I'll give 640, the mental disease or defect expert opinion testimony. 605, instruction on the issue of the defendant's criminal responsibility. Then I'll give 160, closing arguments of counsel. Then you can do closing arguments. And then the closing instruction 460 after you've completed your closing arguments. I've added the verdict form, and the verdict form actually needs to have the heading on it. And I'll make sure that gets corrected before it goes into the jury. But I did fix the request you had, Mr. Freilich. So the question one is, at the time the crime was committed, did the defendant have a mental disease or mental defect? And I did that for question two as well. And in the instructions, when I indicate you're going to be getting this verdict form, I made that correction there as well.
Thank you.
know what, I think what I was thinking was missing, I don't think it is missing. I was thinking 602 needed to be inserted in 100. But that's true, but in the first phase of the trial. And so I think that's where, I think I was thinking of 602, and 602 doesn't need to be inserted in 100 at this phase. Okay. That's what I propose to give, counsel. I'm going to start with you, Mr. Saunders. Any objection to the form of the instructions or the verdict form?
Just on the verdict form, question 1, I think it should read at the time the crimes were committed, plural, instead of the singular.
Right. Because we're dealing with 3, so
Yeah, put that S on there.
that should be corrected. And then when I give 605, question 1 at the time crimes were. Any objection to that, Mr. Fairley?
No, that makes sense. Crimes were, that's what we're talking about.
Anything else, Mr. Saunders?
Oh, there's one more instance. In the top of 605, the defendant's mental condition at the time of the offenses.
Sure. Makes sense as well. Mr. Fairley, any disagreement with that?
Your Honor, are we talking 605, the number 1?
605, the very first sentence says, you have just heard testimony about the defendant's mental condition at the time of the offense, and they're suggesting it should say offenses.
I agree.
Anything else, Mr. Saunders?
I guess it's also on the next page, the first question heading.
What's on that same page, number 1? At the time the crimes were committed.
Okay. Those are fixed. And I don't think it appears any other place. Anything else, Mr. Saunders?
No.
All right. Mr. Freilich, anything concerns about the form of the verdicts or, I'm sorry, the form of the instructions or the verdict?
Your Honor, I see what Mr. Saunders was talking about on that second page, where it's in writing. The first question is, and then it should say at the time the crimes were committed.
We've caught that already.
Okay, but on the first page, what I was talking about, we corrected that first paragraph with an S for offenses.
Yes.
But then if we look down, it says 2 questions, and then it's got question 1 and question 2. Was that changed to at the time the crimes were committed?
Yes.
Okay, I just wanted to make sure. Thank you.
And just so everyone knows, I'm not intending to go back and get that corrected now. I will make sure my judicial assistant corrects that as I'm listening to closings and so when this is delivered to the jury.
This judge wants to rock it out.
Okay, thank you.
In addition, as I've indicated, I'm also going to have the heading inserted on the top of the verdict form. So instead of the title of 605B, which is where this verdict form comes from, it'll have the heading in this case.
You can't have that 220 volt printer fired up when the jury's in there. It's too dangerous.
If there's nothing else, then I'm going to use the same time limits as we had yesterday, but they're going to be flipped. So yesterday I gave the state a half hour and 10 minutes of rebuttal. That's what you'll get, Mr. Freilich, but the state will get 35 minutes for their closing. I'm not sure if you're going to need that much time. The time that I've given everyone each time they haven't used, but I will keep track of that for this time.
Okay.
Anything else before we bring the jury in, Mr. Saunders?
No.
Mr. Freilich?
No, thank you, Judge.
Here we go. Jury time.
Which microphone are we using on the podium? That one? Sure.
Yeah.
Right, be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has any impression of my opinion as to the issues in this phase of the trial, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify but must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the witnesses and the facts supporting their opinions. The court has appointed Dr. Christina Engen to examine the defendant and to testify at trial. You should weigh the testimony of Dr. Christina Engen as you would weigh any other opinion testimony. You have just heard testimony about the defendant's mental condition at the time of the offenses. You will now be asked to determine whether the defendant is not responsible by reason of mental disease or defect. This issue will be presented to you in the form of two questions. First, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Second, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question, yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that the answer to that question should be yes. Evidence has a greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. The first question is, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because the unnaturalness or enormity of the act, or because a motive for the act may be lacking. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? If you answer both of these questions yes, the defendant will be found to be not responsible for the offense and will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, you are to consider only the issue of the defendant's mental condition at the time the offenses were committed. Agreement by 10 or more jurors is sufficient to become the verdict of the jury. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching agreement. At least the same 10 jurors should agree in all the answers made. I ask you to be unanimous if you can. At the bottom of the verdict, you will find a place provided where dissenting jurors, if any, will sign their names and state the answer or answers with which they do not agree. Either the blank lines or the space below them may be used for that purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Now, ladies and gentlemen, the attorneys will make their closing arguments, and as indicated, because the different burden of proof in this case, Mr. Freilich will start. Mr. Freilich, are you prepared to make a closing argument?
Yes, Your Honor.
Go ahead.
Thank you. Your Honor, may it please the court, ladies and gentlemen of the jury, Mr. Saunders, Mr. Lissay. I want to thank you again for your attention. I know that you've been thinking and analyzing and listening very attentively to the testimony from these experts in phase 2 of this trial. The question is whether or not Taylor D. Schabusiness is legally responsible for the crimes that she's been convicted of. And in this case, Taylor Schabusiness has elected not to testify. That's her right. You are not to use that against her in any way, shape, or form. This case is a battle of the experts. We have Dr. Seipel, we have Dr. Engine, and we have Dr. Leighton. The case started off by my client's father, Arturo Coronado, who came in and he testified that his daughter had some problems, some mental health problems, growing up as an adolescent, that he got her some treatment, some counseling, some professional help, that he helped her at Nicolay Psychiatric Center, and that my client lived with him for a period of time. So he provided the framework and the background for some of the issues that this young lady has. And we heard about the fact that her mother died in the home, and she was there. And that was I would submit that was a pivotal event in her life because she loved her mother. Then we moved on to Dr. Diane Lighton, PhD, a doctor, forensic psychologist. And she provided testimony as to her extensive background, her training and experience. And she provided testimony that she worked at UW-Madison as a scientist, that she completed over 3,000 hours of postdoctoral training at Mendota Mental Health Institution, a well-known institution that treats people with mental health problems, and that she became a licensed psychologist in 1993. She worked there doing competency evaluations, NGI evaluations, many other evaluations. And then in 1997, she went and became an independent forensic psychologist where she conducted hundreds of forensic evaluations, including competency, NGI, not guilty by reason of insanity or not guilty by reason of mental disease or defect. We call it NGI. Evidence-based sentencings and guardianship. And so she testified about her background and her resume. Lawyers call it a curriculum vitae, her CV. Bores out all of the experience that she has working in this field, technical field. And she went on to testify about the fact that she met with Taylor Schabusiness in February of 2023 at the Brown County Jail. And Ms. Schabusiness was nonverbal, non-responsive, apparently threw a chair. She tried another approach where Dr. Lighton met with her behind glass and didn't really get any response. Then we heard about the fact that she did meet with Ms. Schabusiness in June of this year, and she was able to conduct her interview and glean and garner information with regards to her mental status and this report that she was tasked with. And I submit that Dr. Lighton testified that she didn't have to do an MMPI, a Minnesota Multiphasic Personality Inventory. She was able to gather enough information from reviewing all of the other materials and information that she had. Interviews, consults with the prior attorney, with me, reviewing all of the other doctors' reports, Dr. Lucetta, Dr. Seipel, Dr. Collins, and other doctors that have been involved in this case. She reviewed police reports, looked at interviews, looked at the criminal complaint, looked at Brown County Jail records, looked at Nicolay Psychiatric Center records when my client was inpatient there, looked at her school records, looked at the Bellin Health records, looked at a lot of information. Basically what we have here is Dr. Lighton, who's very experienced. She did the NGI evaluation. You heard from Dr. Seipel, Matthew Seipel, that he did a competency evaluation. He did not do the NGI evaluation. Dr. Christina Engine, she's the one that did the NGI evaluation. Now, as it relates to Dr. Lighton, she is of the opinion, to a reasonable degree of psychological certainty, she testified that Ms. Schabusiness, Taylor Schabusiness, qualifies for the NGI plea based on her diagnosis of a serious mental disorder. She opines, she concludes, that the serious mental disorder affected Taylor Schabusiness's ability to know right from wrong at the time of the alleged offense, dating back to February of 2022, and affected her ability to control her behaviors. And she finds and opines that Taylor has been diagnosed with bipolar disorder for at least several years. And that was confirmed in the records from Bellin Health. She also says and opines that Ms. Schabusiness continues to have prominent psychotic symptoms and has not used substances for at least 1 year. There was some talk about the feigning, the faking, the malingering. Feigning means faking. About that topic. And Dr. Lighton indicated that it was her opinion that my client was psychotic at the time of the alleged offense, and it wasn't simply due to drug use. It's clear that Taylor Schabusiness had a problem with methamphetamine, with drugs, marijuana, other drugs maybe. Dr. Lighton says that Ms. Schabusiness had a very strange presentation, had facial expressions that can appear inconsistent with the context. If you're talking to her about something, she might smile or grin, and it may not be the appropriate time for that. But she opines that her assessment finds that Taylor Schabusiness has a genuine mental disorder of a psychotic nature, which is most likely bipolar 1 disorder. Now, in this case, you heard that Dr. Engine, with respect to her, she didn't know that my client was under a civil commitment order for Brown County by Judge Lee Joyce. Taylor Schabusiness was found by the court to be the subject of a civil commitment, and that's why she went to Nicolay Psychiatric Center. My client was also the subject of an order for voluntary medication. She had to take medications ordered by the court. No ifs, ands, or buts. Why? Because she was deemed to be having a mental illness. So that's something, ladies and gentlemen, that you should really strongly, seriously take into account. That in April of 2021, for a 6-month period, she was under a civil commitment order because she was mentally ill. When you look at, the report from Dr. Seipel, or you heard about his testimony, I would argue that, his focus is on competency, and competency and NGI are two legal theories, two legal issues that have to be determined separately. But his focus is on competency, and that I would argue that his testimony is not relevant, not germane to the issues that you are tasked with, and that is to determine if my client is NGI, if she meets that criteria. Dr. Seipel, although he's a PhD, his training and experience is much less than Dr. Lighton's. But his focus was competency, and that's not why we're here. Dr. Engen, she testified, and she met with my client on October 12th, 2022, and then again on October 21st, 2022. It appeared that On October 12th of 2022, there was some security issues, so she wasn't necessarily able to meet with my client. But she did meet with my client on October 21st of 2022 and had a 3-hour interview with my client. That's 9 months ago. It's a long time ago. I would argue and submit to you that her report is stale. She didn't receive the Bellin records. She didn't look at those records. Someone else could have given her the records. Maybe Dr. Seipel, he's on the same letterhead. And Dr. Seipel knew that he was doing his evaluation. There was a disconnect. There was no communication between the two doctors, which is something you should consider. There was no connectivity there. Also, with due respect, Dr. Engine, didn't trek from Milwaukee to the Brown County Jail to meet with Ms. Schabusiness to do further assessments or supplements. Didn't do anything to supplement the report. So that's something you should take into account as well. There's an instruction, I believe the judge already gave it to you, but it indicates chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Something to take into account here.
That is pretty thin.
We believe that Dr. Leighton was very clear that Taylor Schabusiness has bipolar 1 disorder, that she has psychiatric symptoms, she has mental health problems. And she made that clear. She talked about the fact that Taylor Schabusiness heard the train, heard the whistle, that Miss Schabusiness lacked volitional control, lacked the ability to control herself, that she is a psychotic person off the scale, that she has a very unusual presentation. And she testified that Taylor Schabusiness, when she interacted with Dr. Litton, that Taylor tried really hard to answer her questions. But Ms. Schabusiness was distracted by internal stimuli, the clock, the cord, voices telling her to hang herself, the train with the whistle that got louder and louder. Talked about 007 and James Bond when she was asked about her mood. Dr. Litton talked about hypersexuality, and that was a concern for Dr. Litton. And about OCD, obsessive compulsive disorder, where Ms. Schabusiness was washing her hands 30 to 40 times or touching her hair, things that were a cause for concern. Wisconsin law, we all have to follow the law, and Wisconsin law is such that the defense and a defendant must satisfy you jurors to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, that Ms. Schabusiness had a mental disease or mental defect, and that as a result, she lacked the substantial capacity to either appreciate the wrongfulness of the conduct or conform her conduct to the requirements of the law. And you're going to be given some jury verdicts, basically questions. Not many, just 2, I believe. One is, at the time the crime was committed, did the defendant have a mental disease or mental defect? I would submit that the answer would be yes. That's my argument. That's my request, that you consider that, and that it was bipolar 1 disorder, based on the testimony from Dr. Litton. Then number 2, you'll have to consider, as a result of the mental disease or mental defect, did Taylor Schabusiness lack the substantial capacity either to appreciate the wrongfulness of her conduct or conform her conduct to the requirements of the law? And you'll have to consider that as well. I would submit that that would be a yes. And I know you know this, but I want to make sure the only issue at this hearing, at this phase 2, the second phase of the trial, is Taylor Schabusiness's mental condition at the time of the offense. So take that into account. It's a difficult case. It's a very complex case. Deals with law, deals with psychology, deals with mental health. A lot of things going on. But I would ask that you take all of this into account when rendering your decision. Thank you very much.
I don't feel like he moved the needle too much on whether she could appreciate right or wrong. Is she imbalanced? Have mental problems? Yeah, but could she appreciate right from wrong? Or have this compulsion to the violence she couldn't control? I didn't see it personally.
I think it was the dope. I blame it on being on drugs and the come down. I barely do drugs, then months go by, then I do drugs. Admitting on multiple occasions, both to evaluators and to law enforcement, about consuming a significant amount of methamphetamine for these offenses, admitting that she and Chad were toking methamphetamine beforehand. She even talked about how she was still tweaking on meth during the dismemberment process. Ultimately, that's what this case comes down to, right? Because as we heard from, I think, every doctor, it's difficult to parse out psychotic symptoms versus drug use. So when we're talking about whether somebody has a mental disease or defect and they're voluntarily ingesting methamphetamine, it's really hard to say that that's due to some other underlying mental health issue, right? And that kind of makes sense in our common sense. But ultimately, that's what this case comes down to. It's the defendant's own words that this was fueled by meth, and now it's, well, no, it's bipolar. It's something else, some diagnosis from way before this offense. And that's not the standard you are to apply. Okay, so first, 2 questions you'll have. Was Ms. Schabusiness suffering from a mental disease or defect at the time of the offense? Not in 2012, not in 2014, not in April of 2021, not in June of 2023 when she's meeting with Dr. Litton, or in July with the other doctor, Dr. Seipel. The relevant question is at the time of the offense. Okay? And I disagree with counsel. And you all sat through Dr. Litton's testimony. I don't think it's clear at all that she's diagnosing the defendant with bipolar 1. She said most likely, seemingly based on the prior diagnosis, but there's never a firm diagnosis, and we heard Dr. Seipel comment on that as well. And you also heard about what bipolar entails, right? What's required? What are some diagnostic criteria, right? We heard about these manic episodes that last a week or thereabout, or even longer, where there's this heightened and manic state followed by a depressive state. You've heard none of that What part of the interview the defendant gave to law enforcement on February 23rd indicates that she's still going through some manic episode? What part of all of the witnesses and evidence you've heard about the time in the night of February 21st indicates that she's going through some manic episode? You've heard none of that. So this idea that this manic episode arose and dissipated in a flash, just happening to be around the 5 minutes where she's actually strangling him and then the day that she dismembers Shad, it's utter farce. There's no basis for that. Instead, we're relying on a bipolar 1 diagnosis from April of 2021. It's a year before the offense. And you heard from Dr. Seipel and Dr. Engen, both of whom are court-appointed. State didn't hire them to come. They're the court's appointed experts. Both of them have issues with that initial diagnosis. You heard why, about the concurrent methamphetamine use around the time of the Nicolay admission. And that's the same story we're seeing now, right? It's the same thing. Methamphetamine use, exhibiting psychosis, and that's unfortunately what led to Shad's death in this case. It's the same thing. So this concept of a civil commitment and the judge ordered voluntary medication, it's not relevant. It's not consistent with the other evidence you saw in this case. What did you see that led you to think the defendant was going through a manic episode, to have bipolar 1 at the time of the offense? That's what's relevant. You're told what a mental disease or defect is. It's something that substantially affects the mental process. That's something else you heard nothing about, right? People can have bipolar 1 and not have their mental state substantially affected. You heard nothing from Dr. Litton to tie that diagnosis, even if we'll give the benefit of the doubt and say she did diagnose bipolar 1, despite the testimony. You heard nothing to tie that into it being a mental disease or a defect. You're instructed that, as we talked about in opening, it's not just because somebody does something really abhorrent and really awful, unnatural. That's not a mental disease or defect. That would be a perverse incentive to sort of reward people to do more deranged things, right? That's not enough. It's not a voluntarily induced intoxicated state. That's what we have here. Mental disease or defect is not a mental state brought about by the ingestion of a controlled substance. So when we heard about meth-induced psychosis, right? Again, that's something that's being brought about by a controlled substance. Those aren't mental diseases or defects. You're responsible in this state for anything you do because you choose to ingest methamphetamine. That's the law. You heard nothing in this case about there being some permanent condition. None of the doctors diagnosed the defendant from suffering from any brain disease because of methamphetamine use or some other substance. Not even her doctors will say that. So when the defense argues that chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect, if the condition has become permanent, nobody is testifying to that in this case. That's not any evidence that you heard. You heard and saw the defendant in the time almost immediately before and immediately after this offense, right? We heard from Dr. Seipel about that, and I think the defense fundamentally misunderstands why the state called Dr. Seipel. Obviously, he didn't do an NGI evaluation. We asked him about that. The relevance is because he highlights flaws in Dr. Litton's report, in her opinion, and that's the sole opinion the defendant's relying on to meet her burden. We heard about why, when you're considering, a bipolar diagnosis, particularly in the NGI context, it's really important to look as close as you can to the proximity of the offense, right? And that makes sense, right? It helps validate if this is actually some manic episode or something that would be throwing a chair randomly at a person, right? But there's a difference between those two things. And we heard none of that. We heard none of that from Dr. Litton, did we? We heard a lot about mental diseases and illnesses that she thinks happened way before, way after. And yeah, she reviewed a lot of material, but Dr. Litton tied none of it into February 22nd of 2022, did she? No testimony about, well, okay, so if somebody has bipolar 1, how is that manifesting? How is that utterly inhibiting the defendant from her awareness of what's going on, or her ability to conform conduct? Right? We heard none of that. We heard a statement at the end that, well, I think she's NGI. I would support the plea. And you heard no analysis, right? No analysis of, well, I considered the defendant's actions the night of the incident, and this raised this concern for me. That would support my opinion. We heard none of that, right? And it's their burden to do so. You heard none of that from Dr. Litton. She's, yes, qualified, experienced. We heard about that. But there are real issues with her methodology in this case. Based largely, her opinion is, on her interactions with Ms. Schabusiness on June 19th of 2023. And we heard ample reason why that should be a red flag. People who actually administered personality tests to kind of determine feigning and over-exaggerating of symptoms, including experts hired by the defense, have raised that concern for the defendant that she over-reports symptoms, that she exaggerates symptoms. And Dr. Seipel is exactly right. And you heard the testimony from Dr. Litton. Most of her opinion is based on her interactions with the defendant and this bizarre behavior that she's observing. Incidentally, bizarre behavior you haven't observed for 1 second during this trial. For the last 4 days, there's no throwing chairs, there's no outbursts, there's no staring or off, right? So this idea that Dr. Litton's opinion, based on her interactions with the defendant and some old bipolar diagnosis, there's nothing tying it together. There's nothing showing you that would allow you to agree with her opinion that the defendant had a mental disease or defect on the date of the offense, which is the relevant question you have to answer. You have reported behaviors by Dr. Litton that aren't in any other reports that are observed by doctors. Dr. Seipel meets with her really close proximity, isn't reporting any of these behaviors. And again, one of the questions you have is capacity, right? Substantial capacity to do things. And there's a big difference between capacity and desire to do so, with volition, with choice, right? The capacity to go skydiving. I don't have the volition to go skydiving. I have the volition to dunk a basketball. I probably don't have the capacity to dunk a basketball, right? Those are different concepts. And the information you heard about in the records from the testimony is that it's something that the defendant can control to some extent, right? There's no outbursts or any of the behavior Dr. Litton's talking about that Dr. Seipel observes, that the court-appointed expert, Dr. Engen observes. None of that, right? To the contrary, you have Dr. Engen doing scientific tests to determine about the validity of some of the observations and determining the opposite, right? And sure, Dr. Litton was under no requirement to do that sort of testing. But when she says she just looked at the prior results and relied on those, well, what she should have been relying on is that the information the defendant's telling her isn't accurate. That's the only prior analysis that we heard about. So again, there's real methodological issues with Dr. Litton's report. Most importantly, none of it ties together with the date of the offense. Her testimony, for the better part of this morning, maybe 2 or 3 questions dealt with the date of the offense, tying it together. Dr. Litton, how are you able to tell this jury that Ms. Schabusiness was unable to conform her conduct, was not aware of what's going on? You heard none of that. She didn't even review the entire video, the recorded interview that you observed, to see firsthand, really close proximity to the date of this offense, what the defendant's behaviors were. She reviewed a transcript. I think she said she may have reviewed 90 minutes of it or something like that. Didn't review the second interview, which incidentally, as you observed, and you heard from Detective Graff, the same behavior, same mannerisms, same lack of outbursts or anything like that throughout this time. Again, this manic episode that is allegedly occurring. You observed that over several days and didn't observe any of that. So that's the concern with Dr. Litton's testimony, and that's the relevance of Dr. Seibel's testimony. He points out some of these issues. As he interacted with the defendant as well. Didn't observe any of that on multiple occasions as a court-appointed expert. Again, not hired by the state to come in and say that, report that. So you have the report from Dr. Engen, the court's expert. And you heard the testimony, and if you review the report, it jives with common sense, right? There's no mental disease or defect that she talks about. The mental illnesses, which there seem to be, are all substance abuse related. And again, the law of this state says that's not enough. That's not a mental disease or defect. So sure, there's, I think, amphetamine disorders and methamphetamine intoxication. She says, yeah, I would support these illnesses. Those aren't mental diseases or defect. She considered a bipolar 1 disorder and rejected it for the reasons we talked about. Given the concurrent use of methamphetamine, it seems like the doctors that the court appointed agree that you're using meth. You're not psychotic. Any psychotic symptoms you're exhibiting are because you took meth, not because you have some diagnosis or have a mental disease or defect. So when you're asked the first question, when you see the verdict form, that question should be answered no. You've heard insufficient evidence that the defendant suffered from a mental disease or defect on February 22nd, 2022. Okay. If you answer that question yes, and only if you answer that question yes, you get to the second question. Second question asks sort of a compound question. As a result of that mental disease or defect, did the defendant lack substantial capacity, again, capacity, to understand the seriousness of her conduct or to conform her conduct to the requirements of law, right? So understanding and conformity are kind of the two things there. So let's talk about that. You obviously heard from Dr. Engen about that, about how she does not support that. She does not believe that she lacked substantial capacity to have either of those two things, right? And her reasoning makes sense, and really it's kind of reasoning you probably would have gotten to without her testifying in some respects. It helps that this expert that the court appointed comes in and tells you that too, but it jives with common sense, right? Because you heard all this evidence for Monday, Tuesday, Wednesday, and today about the defendant's conduct on February 22nd, 21st, and into the 23rd. She's aware of the wrongfulness of her conduct, and she's telling you as much, right? She tells law enforcement, I took these Clorox wipes and I was wiping up, right? Specifically, even accurately remembering it's Clorox wipes and where she put them in the bags. Detective Scanlon on February 28th asks her, hey, we saw some wiping pattern on the floor, and what was going on with that? And she was like, yeah, I was cleaning up. And they're like, well, did you move the bed over? She said yes. And why did she say it? Why did she say she did that? She was covering it up. Right? And that's why we ask those questions about the blood that we saw on the floor under the mattress isn't seeping through the mattress. It's coming because the defendant moved the bed over it, because she's trying to cover up her crime. And now they want you to believe that she's not aware of the wrongfulness of her conduct? She's telling law enforcement, how am I going to get away with this? That was her motivation for dismembering his body for a lengthy period of time after the fact. Hearing footsteps upstairs, worrying mom was going to find him. She's telling you she's aware of the wrongfulness of her conduct, and she's exhibiting action and volition to clean up. everything you're objectively seeing evidence-wise in this case shows you that she knows exactly what's going on. She even remembers details about this night. And now that we hear this professed amnesia in her comments to Dr. Engen about this offense, and you saw the interview, she had every detail down to the T. She could have drawn that entire basement for you from memory. Where everything was located. She's telling you where the meth is located, where the dildo is located, what color the dildo was. She's aware of what's going on, even with the meth use. You have her memory of the incident. You're hearing about how she's describing, and you could probably infer from the nature of the offense how blood was going everywhere in the course of the conduct, yet you heard about the condition of that basement, right? It was pretty spotless, pretty clean, especially considering what happened down there. Because she cleaned up. Because she was aware of the wrongfulness of what she did. She didn't just massacre somebody, dismember him, and leave a war zone down in that basement. No, she cleaned up because she knew what was going on. Then you get to the second part, right? If she's able to conform her conduct to the requirements of law, and again, you heard nothing from Dr. Litton to kind of help you with that, right? Like, okay, if I'll accept she has this bipolar diagnosis, well, tell me, Dr. Litton, how is she unable, because of that diagnosis, to conform her conduct on February 22nd? And you heard none of that. To the contrary, as Dr. Engen points out, you have a lot of information to tell you she's able to conform her conduct pretty well, right? She's employed. We heard about court cases that she was dealing with. We heard about paternity things she was arranging in the time leading up to the offense. We heard about after the fact, we saw the contact with law enforcement, right? She's ordered to take her hands out of her pockets for officers. She does that. Order to put her hands behind her back. She does that. Complying with orders, complying with commands, complying with questions. She's conforming her conduct pretty well, right? She's following the law enforcement's commands. In her interview with law enforcement for a lengthy period of time, she's conforming her conduct. She's not exhibiting any manic symptoms. She's not exhibiting any psychosis in that you heard about. There's just nothing in this case to show that she's not able to conform her conduct. To the contrary, you heard a lot of evidence that not only did she not lack that ability to conform her conduct, that what she did to Shad was volitional, was a choice. She liked it. She was aroused by it, right? She told law enforcement that. She wanted to do this. She did. Because that was a volitional choice. It's not because she lacked substantial capacity to not do so. It's because she wanted to do so, and she did. You heard about her saying, well, yeah, I knew I was killing him, but quote, I did it anyway, right? Because that's what she wanted to do. Again, a mental disease or defect is not because you may not have a clear understanding of a motive. I would say you should, but that's not a mental disease or defect. Just because what she ultimately did is in some respects quite disturbing, it's not a mental disease or defect. You have insufficient evidence to support that. And again, it's not the state's burden to disprove an NGI plea. I think we have, but it's the defendant's burden to convince you of the NGI plea, and they've utterly failed in that respect. We heard about
I think
burden
Taylor's
of
odds of her case,
that,
she's thinking, are the
it's
same
a
as we're
reasonable
thinking.
certainty by the greater weight of the credible evidence. And you should be, even though it's not our burden, I would say you should be reasonably certain the defendant's not suffering from a mental disease or defect. again, it's their burden to convince you that you should be reasonably certain by a greater weight of the credible evidence that she does. And it's their burden. If they wanted the court's expert to review documents from 10 years prior, they could have done so. They could have provided those materials. If they wanted, hey, please interview my client again, they could have done so. It's their burden. And they chose not to. There was additional jail records. They could have produced those. And actually, Dr. Engen's comments about that make sense. You know, her findings and all the objective evidence you have is this is a meth-induced crime, that whether she had a civil commitment a year prior, had, I think, a mood disorder 10 years prior as a 14-year-old, that's not relevant. It wouldn't change anything. I don't understand these arguments about the reports being stale. As Dr. Engen told you, it's a retrospective review, right? We don't really care. You're not asked to decide, does she have mental disease or defect today? That's not important. The proximity to today isn't relevant. It's the proximity to the offense. You should actually be entirely convinced Dr. Engen's report is the more relevant report. It's closer in time to the actual mental state the defendant had on February 22nd. It's obviously a complex case in some respects, right? It's a serious offense that the defendant was convicted of. It's obviously it's an important case, right? And the defendant has had experiences in her personal life that nobody should have. Losing parents at a young age, it's something many of us deal with, and it's awful to hear about. It really is. But that doesn't change the law. That doesn't change the standard in this state, because there's simply no evidence to support she had a mental disease or defect on February 22nd, 2022. Not only did she not have a mental disease or defect on that day, you have no evidence to say that that mental disease or defect rendered her substantially incapable of conforming her conduct or appreciating the wrongfulness of her conduct. You simply don't have that evidence here. You have ample evidence to the contrary. The defendant is telling you that meth made her do this. She's repeatedly told that to law enforcement. Every objective piece of evidence you have in this case supports that finding. And it's simply the case that that is not enough in this state. That's not a mental disease or defect. So don't let her now try to come in and say this was some other thing. Now the meth really didn't have anything to do with it. It's important to note, a meth-induced psychotic state is also not a mental disease or defect, as you'll read in the instruction. There's no mental disease or defect. There's no lack of awareness. There's no inability to conform your conduct. You have ample evidence to the contrary. And that leads to one inevitable result, is that she's responsible for what she did to Shad on February 22nd. As a result, you should answer both questions no, or answer the first question no, and don't get to the second question. Thank you.
Mr. Fraley, do you have a rebuttal?
Yes, I do, Your Honor. Thank you. Your Honor, again, may it please the court, ladies and gentlemen, Mr. Saunders, Mr. Lissay. You know, this case illustrates that this young lady, Taylor Schabusiness, has a lifetime of mental health issues. She has bipolar I disorder. That is a mental disease or mental defect. You know, who is the state fooling? We have a young lady that was under a civil commitment order and a medication order by the Brown County Circuit Court in 2021. So she already had a mental health disorder, a mental defect, I submit a mental disease, that predated the incident that has brought us here to court on February 22nd of 2022. It's clear in this record that Ms. Schabusiness was at the Nicolay Psychiatric Center for 3 weeks or so, maybe a month, in 2021. You got to see in phase 1 of this trial Green Bay police officer Garth Russell, who parked his squad down quite a ways, and he walked in the dark of night across the snowy parking lot up to the Eastman Avenue apartment at 2353 Eastman Avenue. And Ms. Schabusiness Officer Russell met her at the door, out on the porch. And you could see on the video her face. You could see her eyes.
Doing his own Taylor.
You could see her demeanor. She didn't look right. I submit to you, she didn't look right. Something was going on.
Even she's like, what? Look at her. What?
Did this happen when she was in a manic state or a psychotic state? I submit that, once you have a mental health issue, mental health diagnosis, a mental health issue like bipolar 1 disorder, it's not going away. It follows you for the rest of your life. What we have here is someone who has a very serious mental health issue, mental health disorder. And you pile drugs on top of that. It can constitute a mental disease or defect if the condition has become permanent. I would submit that Taylor has had mental health issues dating back to her early years. She went to Purveya, she went to Bellin, she went to Nicolay, she was under a court order where she had to have injectable antipsychotic medications. She apparently was psychotic when she was at the Nicolay Psychiatric Center. I would submit that it wasn't necessarily from drugs. She's got this underlying issue here. She has ongoing mental health issues. She's only 25 years old, and they've been going on since her youth. I would argue that the mental health issues that she has caused this whole situation, and that'll be something you have to think about. Is she able to appreciate, or was she able to appreciate the wrongfulness of her conduct on February 22nd of 2022? Was she able to conform her conduct to the requirements of the law at that particular time? And you saw the video. We all saw it. It was very bizarre, very unusual, very odd, her demeanor. In this case, there are a lot of doctors, but Dr. Engine, she never knew about the civil commitment order. Come on. You didn't know about a court order? And she's a PhD and she deserves respect, but something happened here where it fell through the cracks that she didn't know about this civil commitment order or this medication order. And then we have Dr. Seipel, he got the Bellin records, got them from me. And, he does a report for this case, and I find it incredible. It's incredible that he doesn't send, with due respect to him, he doesn't send the Bellin records over to Dr. Engine, knowing that she's going to come in here and testify in a court of law in front of you jurors. I find that unbelievable. I don't make the law. But the law, the law because the judge read it to you. You have to consider whether she's responsible because of a mental disease or defect. So you've got to think about all of that.
But you
The
got the
defense
burden,
didn't
Roy.
fail.
Got
There
the burden.
is a plethora of evidence to show her mental health history. Was her bipolar 1 condition permanent? I submit to you that it was. Did it cause a crazed situation for her on the date of this fatal incident? You heard Detective Groff, who's a very seasoned detective with the Green Bay Police Department. You heard him go through very methodically questions. He was patient. He asked Taylor Schabusiness lots of questions about what was going on. And he testified that the police detectives and the officers, it was an ongoing investigation and they didn't have all the facts. They didn't know all the things that were going on. It was evolving. Detective Scanlon was over on Stony Brook and Detective Groff was at the police department. She told Detective Groff, I didn't intend to do this. Me and Chad were buddies. Words to that effect. So I submit that she did not want to do this. At the time, was she in a state of psychosis? Who knows? That's for you jurors to decide.
No, she's in the
But
state
we've
of Wisconsin,
presented the lawyers, Mr.
and she's guilty of murder.
Saunders, Mr. Lissay, and I have given you the information, the evidence for you to wrangle with and think about and analyze and assess. I would ask that you consider the fact that Ms. Schabusiness was taking the antipsychotic meds, the injectable meds, when she was at Nicolay Psychiatric. And then once she was released, didn't take it anymore. We all know if you don't take your medications, you're going to have problems, especially if it's a mental health condition. If you don't take your high blood pressure medication, what's going to happen? Your blood pressure is going to go up to the sky and you could have a heart attack or stroke. Same thing rings true for other medications. And in this particular case, Ms. Schabusiness did not take these medications. So I would submit, her mental health problems, her bipolar 1, got worse and worse and worse and worse to the point where it went off the cliff. I would submit that based on everything that's been presented, I'd ask that you consider returning a verdict that she is not responsible for these crimes by reason of mental disease or mental defect as applied with the jury instruction. Thank you very much.
Well, that should be it for the lawyers.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a fair, just, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. Do not be swayed by sympathy, passion, or prejudice. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. As with the case in the prior phase, you will be getting a copy of these instructions with you during your deliberations. With that, I'd ask the bailiffs to step forward to be sworn.
Gentlemen, put your hands, and ladies and gentlemen, put your hands on the
Do you
printer,
swear
please.
that you will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I do. All rise for the jury.
Congrats to Taylor and made it through the trial without killing anybody. It probably cost people some money on bets. Didn't stab anybody.
Anything to bring
Nothing.
up before we recess? Mr. Saunders? No. Mr. Freilich?
No, Your Honor.
All right, then I'd ask, as with the situation the other day, I'd ask if everyone remain around for 30 minutes until 6 o'clock or so. After that point, if you want to leave, if you could just leave a cell phone number where we could reach you. And with that, we are in recess.
Thank you.
That is correct. They are Presbyterians. Dang, she shook hands with the guy. So she's stoked. I thought that was good, bro. I buy it. I like it. I'm going to leave your head on you. There's a thumbs up to you. So that's it. No after action stuff after the jury's out of the room. So it's just down to the verdict, which leave you with this. The burden's on the defense, and it does not have to be unanimous, just 10 out of 12 in either direction. So that's it for this for now. And I think we probably, you probably won't have to wait long to hear what the verdict is on this. So I'm about to shut this puppy down, and thanks for everybody for coming in and talking through this case. It's important how people's rights are protected, and she got that with her lawyer making arguments on her behalf. She obviously did do the crime. The only question is whether she should be held responsible for it due to insanity. I was not persuaded of that by her side. So anyway, thanks guys, and have a good evening. I'll talk to you later. That's it. Bye.